Good morning, everybody. If we can make a start, please. Can everybody hear me? Can you hear me at the back? Good, thank you. That's just gone 10 a.m. on Wednesday, 14th of January 2026. Welcome to our second session in this public inquiry for the proposed Lees Hill Renewable Energy Park, DPA reference WIN-140-10. Today's hearing session will be covering landscape and visual, including cumulative and residential visual amenity matters. There's various bits and pieces that I just need to go through before we start, so I'm going to do that. My apologies if you heard bits of this before. This will be the abridged version from Monday, so you won't have to listen to all of it. My name's Nick Smith. I'm a reporter working for Scottish Government's Planning and Environmental Appeals Division, also known as DPEA. I've been appointed by Scottish ministers to prepare a report and recommendations for them about whether the proposed development should or should not be granted consent under Section 36 of the Electricity Act 1989 and deemed planning permission under Section 57 of the Town and Country Planning Scotland Act 1997. Before we get underway with today's proceedings, I need to just run through some procedural housekeeping matters, so it should take about 5 minutes to do that, and then we'll be on with stuff. We are broadcasting live on the internet today, so you know that. The sessions will also be recorded and stored as part of the DPA webcast archive and be capable of repeated viewing. By participating in these sessions, participants are consenting to being filmed and to the use and storage of those images and sound recordings and any information pertaining to them contained in those for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Further details can be found in the DPA privacy notice on the relevant part of the gov.scot website. Colleagues from DPA are looking after that side of things for us today, so we've got David and Connor in the room assisting me today. On that, you've got the mics in front of you. Those can be operated by pressing the button on the right-hand side. If you're moving them, please use the base to move them and not the neck. Otherwise, you will be glared at by Connor and David, and that's something you don't want. Please just move them there. You can adjust the direction of the mic. They're flexible, but please don't pick them up by the neck. Social media and photographs. For data protection and privacy reasons, we request that participants do not take any photos or other recordings of their own during the sessions unless those being photographed or recorded have consented to this, and for the record, I don't. So for everybody's benefit then, today's session is a hearing session, which is a roundtable discussion involving the participants who've opted into the process. There is a structured agenda, which I circulated to the parties before Christmas, and we'll be using that agenda for the basis of today's discussions. Some copies of the agenda are available in the public gallery for those who want to follow along. I had originally printed about 10 of those. I think there's only 4 left. Maybe 5, so please be kind and share those around. I'll be reading through the agenda, so if you've not got one in front of you, you'll be able to hear what it is we're going to be talking about. And please, we've only got a few left in the room, so please don't walk away with them or we'll have none for tomorrow. So grateful if you can leave those behind. We'll look to take a break, perhaps around 11 o'clock, depending on exactly where we are on the agenda, for probably about 15 minutes. We'll look to take a lunch break at about 1 p.m. for about an hour, and we'll look to finish around 4 p.m. today. We may get through the agenda more quickly than that, so we'll see how things proceed. If we get past lunchtime, I'll probably take soundings about timings for the afternoon. At the end of the inquiry on Thursday, on Monday, the parties agreed that we would bring forward Friday's proceedings to tomorrow. They were optimistic that we could get through today's proceedings in one day. So the policy and draft conditions sessions previously scheduled for Friday will now be tomorrow, Thursday. And with a fair wind, we should get through those by the end of Thursday, and that will mean that we wouldn't need to sit on Friday. I'll formally close the inquiry once the end of the draft conditions hearing happens, and the participants will then have an opportunity to submit closing statements, and the timings for those have already been agreed at the pre-examination meeting that happened in September with the participants. All documents have been submitted electronically and can be found on the relevant page of the DPA website. The applicant has kind of provided some laptops which are in the room, so if you're sitting on the back row, just on the ledge behind you is a laptop, so if there are documents that are being discussed and you want to open them and have a look, you can do that. There's a table in the room at the back. There are 2 large folders on there with maps and visualizations and wirelines, so when we're discussing them at the table, if you want to have a look at those things, you can as well. And someone should be able to assist you in just finding the right page. I think the document that is closest to the back of the room has in it viewpoints 1 to, I think, 16, and viewpoints 17 onwards, and other relevant visualizations are in the one that's nearest me. So you can get up and have a look at those when we're talking about it, if that's what you'd like to do. I carried out my site inspections in September 2025 and was also able to get out again yesterday, so it was good to be able to do that. No fire alarm is expected today, so if it goes off, it's real. So if that happens, please make your way back out the way you've come in. The emergency rally point is just around the corner at number 6A in the square. There's a fire register doing the rounds somewhere on a clipboard. Somebody will have that. So if you've not had a chance to sign that yet, please do. And I will know who we've got. And if the fire alarm does go off and we're standing over there, please don't go somewhere else until I've accounted for you. Otherwise, we won't know that we've got you. Toilets and kitchen facilities are just through the double doors there to the left. We have a ramp that is there as well, so please just be aware when you're walking through there that maybe a ramp just to the left. There's a lot of documents and a lot of cables and a lot of coats and a lot of bags in the room, so please help avoid tripping hazards by keeping an eye on where those things are and being aware, making sure that you're just storing those things out of walkways and what have you. There is a cable tidy that I think is just next to Mr. Campbell, so please do be aware if you're walking down that narrow section that there's a slight bump in the walking route there. So I nearly demonstrated that this morning before you all arrived, so just please be aware of that. Phones and devices to silent, please, and that way that avoids disturbance during proceedings. If anyone's taken ill during the proceedings, then we'll seek the relevant medical attention and we'll adjourn, and then we'll come back to things as soon as we can. Courtesy and behaviour. I'd like to remind all participants that everyone who's observing of the importance of being courteous with each other throughout these proceedings. You'll no doubt hear people saying things that you do and don't agree with. Please be polite and respectful. Please give other parties the time and courtesy they need to express their views, give their evidence, and answer the questions in the same way that you would expect this to be done for you. I need to hear what each party has to say. I know that there's differences in points of view. I don't expect to have to listen to things like cheering or clapping or heckling or any of that sort of thing. So if you're participating today, then your job is to answer the questions at the point and when it's necessary to answer them, and to listen otherwise. And in the public gallery, it's even easier. Your job is to listen. So the principles of courtesy and respect for other participants extend beyond the confines of this room, so also request that those principles are followed if those taking part today are commenting on proceedings via social media. And as mentioned earlier, please no photographs or recordings other than the DPA webcast. So none of those should be published unless those featured consent to doing so, and again, I do not. Do we have any members of the press in the room with us today? If you could make yourself known. No? Okay, thank you. I'm not aware of any weather warnings for this part of the world over the next couple of days. We'll keep an eye on that. I'm aware there was a frost last night, so do just please be aware that there may be slippy bits just outside, so take care with that. Building security, we are in a public building, so people coming in and out, so just remind you to take valuables with you when you leave, and we'll be locking up after we go tonight, so please do remember car keys and phones and all the rest of it. Okay, that moves us on to beginning proceedings. If we can start with the introduction of parties, so I'll ask the applicant and then the council and then Mr. Campbell Mr. Trinick, please.
Thanks, sir. Good morning. My name is Marcus Trinick. I'm a solicitor and of King's Counsel. I'm instructed by Amy Howard of Wright Johnson Mackenzie, who sits two to my left. My witness for the hearing session is B. Dower, who sits to my left. To Amy's left is Emily Galloway, Senior Project Manager, Fred Alston Renewables, and to her left, Pip de Klerk of Wright Johnson Mackenzie. Thanks, sir.
Thank you very much. And the Council, please.
Good morning, my name is Sarah Thompson, Solicitor for Scottish Borders Council. To my left, I'm joined by Kyle Wise, Planning Officer. To my right, Kilda Platt, Landscape Architect. And at the end of the table, purely in an observational capacity, we have the Council's very newly appointed Landscape Architect, who's here purely to see how things work.
Thank you. Good morning to all of you. And Mr. Campbell, please.
So good morning. My name is John Campbell. I'm a retired advocate in King's Counsel. I'm appearing here as a layman. I am part of and represent Dunsleys Hill SOS. Mr. Paul Whitfield is sitting to my right. He's one of my clients. Mrs. Hattrick is not here, but she's provided a written statement. And I am sharing Miss Kilda Platt with the council, lucky you, as my landscape architect.
Thank you. And I have a written statement from Leader Hattrick, don't I? That was submitted with. I have a written statement from Leader Hattrick that was submitted with your material.
That's right.
Yes. Okay. Yes, we weren't sure if she was going to be in attendance or not, so understood. Okay, thank you for that. Are there, before we get onto the agenda, are there any updates or matters for me before we start? Mr. Trinick?
Yes, sir, a few. Firstly, that we have sent, or Amy has sent, updated statements of agreed matters on cultural heritage and policy and landscape and visual to the case officer.
I received those this morning in the email, so I've picked those up, so thank you, because I think you said you were going to do that by the end of Monday, so they've reached me anyway, so thank you for that.
Secondly, the conversation about the accuracy of certain visualizations continues, and I'm going to encourage the relevant people to talk to each other in the first break. We might have an extended first break for that purpose to try and resolve the matter before we get on to the item in the agenda and see where we get to. Thirdly, when it comes to conditions other than noise conditions, there have been productive discussions with the council, and rather than present you, but we'll do it if you want, with a complete new set of conditions, knowing you probably scribbled over your existing set, I've asked Ms. Howard to send an email updating the relevant conditions by reference to your agenda, where there's been a change in the position of the parties since your draft. Okay. That seems the most efficient way of doing it, rather than giving you a whole new set.
And is that something that's on its way to me or has been submitted? Or
it's on its way this morning. And finally, on noise conditions, I think this may be a matter which will have to be dealt with in closing submissions, probably. And we will involve Mr. Campbell, as he's requested in that. The reason for that is we received yesterday afternoon, no complaint, that's when we received it, a revised noise condition for the battery storage and solar, which is going to need some unpicking and understanding and discussion.
There's been a note that discussions were ongoing, and it was the purpose of the points being made in the agenda was to pick that up. I understand what you're saying to me. I'll let the others come back with anything in a short moment. Did you want to tell me any other things? No, is that it? Okay, I'll go to the council and then Mr. Campbell. So, council first, please.
Yes, so discussions are still ongoing, but conditions are, I think our noise experts are hoping to speak today, but it may be that we're not in a position to come to any conclusion in relation to those conditions ahead of tomorrow.
On that matter, I hope the noise experts will speak to me as well. I agree, though, that we should be talking about the wording of the condition, not the substantive matter of noise. So I'm hoping that my learned friend Mr. Trinick will embrace Dunsleys Hill in that discussion, so that we can see at least where there is common ground, even if we don't agree.
And I believe he's just made that commitment to me. Did I understand that properly?
Consider yourself embraced.
There we are. Right. Okay. I'm content with that arrangement. If if discussions have moved to an extent whereby tomorrow we're able to discuss it, then so be it. We will. If we're not in a position to do that, I think you're probably correct. It falls to closing submissions, and that way, Mr. Campbell and his clients and the council will be able to put forward their position, and the applicant will be in a position to respond. And I'll have in front of me stuff. And I suspect if there's anything else I need, I'll simply have to come back to you all. And in the event that I do that, I'll ask the relevant party for the information. I'll invite the others to comment. And then if there's anything further, we'll deal with that in that way. Did anyone want to respond on that before I move on to the agenda? Okay, so I never asked actually. Did the council have any other updates? You responded to Mr. Trunnick's, but was there anything for me?
No, nothing further.
Mr. Campbell, was there
I
anything?
have one, and it's a personal matter, but you've set a date for closing submissions. I'm going to ask you to push that out for a week for pressing personal reasons, which I don't want to discuss in public. And I can confide those in you during a break. Confide in you during a break, but I don't want to discuss them in public.
I understand that you wouldn't want to discuss certain matters in public that are personal in that way. I'll invite the council just to come back and certainly in principle about the extension, and then Mr. Trunick, if it was to be extended by a week, what I would probably suggest is that was extended by a week for all parties who are submitting first, yourself, the council, and others, and then the timeline for the applicant would commence at the point at which those had been submitted. But I'll invite. Does that sound? Is that what you had intended when you asked the question?
That's what I'd assumed. Yes.
I have no difficulty with that.
Mr. Trunick?
That's fine.
Okay. In that instance, you don't necessarily need to confide in me. I think the decision is taken, but you're welcome to do so if you wish. Okay. If there's nothing more, then we'll move on to the substantive matter of the agenda. So this moves us on to matter one. So what I'll do is I'll read through the points in the agenda, and then we'll tackle them as we go through. So matter one, landscape impacts and effects. The applicant's hearing statement advises that the best method to consider the impacts and effects on the Lammermuir Hills Special Landscape Area, SLA, is using the principles of the NatureScot Guidance for Special Landscape Qualities, which is document 012.030. Its hearing statement and Environmental Impact Assessment Report, EIAR, Technical Appendix 6.5, each reference descriptions of why the SLA, the Special Landscape Area, was designated. The hearing statement breaks down and tabulates the individual geographic elements and determines which would or would not be affected by the proposal. Point A, is the method outlined by the applicant the best one to consider the impacts and effects of the proposal on the Lammermuir Hills Special Landscape Area? If not, what is a better alternative? Point B, is the citation or descriptor used by the applicant in its Environmental Impact Assessment Report and in its hearing statement the correct one, and if not, which alternative should be used? Is the applicant's hearing statement correct that it is the impacts of the proposal on the Durrington Laws part of the Special Landscape Area that is the point of disagreement between the applicant, the council and other parties? And if not, what other reasons for designation would be affected? And part D, what are the specific differences between the parties which led them to conclude differently for the effects of the proposal on the Special Landscape Area? So we'll run through each of those individual points, and I think that'll allow us just to concentrate on the relevant matters for each one. So we'll do A first, so I'll just read that again so people know where we are. So is the method outlined by the applicant the best one to consider the impacts and effects of the proposal on the Lammermuir Hills Special Landscape Area? And if not, what is a better alternative? So I will ask the council first, and then I'll go to Mr. Campbell, and I'll invite the applicant to come back.
Yes, I would say that is the best approach. It follows best practice in terms of NatureScot's guidance for assessing designated landscapes, and it allows the key characteristics of the designated area to be taken in turn and assessed against the impacts of the proposals.
And I take it you're speaking for both the parties that you represent on this occasion.
Yes, that would be for the council and for DLS.
Did you want to say any more before I invite the applicant?
No, I'm happy with that.
I'll invite the applicant to respond.
Good morning, sir. First, if I may just let you know that I'm rather hard of hearing. So at the moment I'm doing all right, but just in case I look blank, it may be because I haven't heard. So I apologise. Yes, in response, I believe that it's the same methodology is suitable. It was, however, written for national parks and national scenic areas, as it says on page 1 of the document itself. So it's not specifically designed for assessing effects on locally designed landscapes. However, it's based on a systematic consideration of the effects going through the different key qualities as sequential steps, and therefore it's a logical way of approaching it. That's really why I used it in my hearing statement. It's certainly guidance that's been used for SLAs since it was published last year for assessment of SLAs. Many applications lodged later have included it, and it certainly was used as methodology for 2 recent inquiries at Carlachi, which I think is code is WIN-140-10, and Loch Leith, which is WIN-279-26. So both of those were considering the SLA close to those sites, which was the Loch Ness and Dunkelhaig SLA. Those are not before the inquiry, but that's just a reference if you should need it. So yeah, the technical appendix did not use that guidance because it wasn't published at the time. So it's considered the description of the SLA and went through those points in that. So and also in answer to your second part of your question, I'm not aware of a better alternative. Thank you.
So you mentioned to me the guidance itself was designed to be used for NSAs and national parks, but there doesn't appear to be a dispute between you about the fact that the principles that are established by that guidance and I think I'll use the word methodology, but the systematic approach that it sets out is applicable to other designations. You've given me examples of that, but that's the point I understood you to be making to me.
That's correct, sir.
Excuse me, after a few days inside over the last few days, I seem to have developed a cough, so I'll do my best to keep that off the mics. And you mentioned that the environmental impact assessment report, the technical appendix, hadn't used the guidance because it wasn't published, but were you saying to me that the approach it used is consistent with that guidance, or at least the principles of it, or was it very different?
Effectively, it's consistent because it follows a logical approach of looking at the various aspects of the landscape and what effects they would have on it, and looking at the effects and the implications on the SLA designation. Yes.
Thank you for clarifying that. Did you want to come back at all on any of the things that you've heard?
Just to add that the approach to work through the key characteristics of the special landscape qualities and to also look at the potential geographical extent as it impacts on the SLA. So different ways to judge those determinations.
And in your opinion, are those things that have occurred in the assessment that's been carried out?
Yes, I think in the hearing statement it clearly goes through the special qualities and makes judgments over which are affected and what the impacts are. And there is a discussion of the geographical extent of the effects as well. So
there's largely no dispute on the points set out in A, where methodologically there is no disagreement.
Yeah, I would say that's correct, sir.
I'll let you come back if you want to.
That's fine, thank you.
Okay, let's move on then to part B. So is the citation or descriptor used by the applicant in its environmental impact assessment report and in its hearing statement the correct one? And if not, which alternative should be used? So I'll invite the Council on DLH SOS to come first, please.
Yes, so my understanding is that you're referring to the designation statement description paragraph?
That is correct, yes. I've used the word description and citation here, but I understand it to be, I think, what you're talking about.
That's good. I just wanted to clarify that I was looking at the same thing. So yes, I was happy that it's quite a brief designation statement for the SLA, but that the key factors are included in the determining designation statement, and that the splitting down of that statement into qualities is an appropriate way to determine what those qualities would be.
Did you want to say any more before I invite the applicant?
No, that's fine.
Over to the applicant, please.
Certainly, I also believe that it's the only and the statement that's available and most recent. Yes. I've also set out in my hearing statement that I think some of the, well, most of the points that it makes are descriptive and aren't technically reasons for which the area has been designated. Some of the statements within it, sorry, some of the sentences, some of the points within it are fairly generic and fairly broad, and can be used to describe many other landscapes in many other places. There are some that are more specific that we can actually use in more detail. So looking at the statement of importance, the geographically specified places are Dirrington Laws, the Upper Whiteadder Water, the Aberson Bathans area, and the hill edges over the Leader and the Whiteadder Water. Those we can actually look at in more detail. Other points are a lot more generalised, such as openness and habitats, and aren't necessarily reasons for which the area was specified, has been designated in terms of its difference from one area to another area which has similar characteristics, perhaps. There are also points within the description that, again, I don't think are reasons for designation. For example, at the bottom of the statement, one might ask whether was it designated because of the B6356 road along the Whiteadder Water. This is clearly not the case. So I think the statement is descriptive, and quite a lot of it is needs to be treated so. Thank you.
But I suppose, nevertheless, in your assessment, is it fair to say that you've attempted to identify the geographic ones, or the ones that you did consider to be part of the rationale for the designation, and you've attempted to analyse those using the approach that we were discussing some moments ago? Is that a fair synopsis of what you believe you've done?
Yes, that's correct. Yeah.
Did you want to say any more before I come back to the Council on DLHSOS?
I think that in my hearing statement, I've been through each of the sentences and taken them as raw data, if you like. I note that Ms Platt, in her hearing statement, has set out key qualities. I believe that's her interpretation of what the key qualities are. I have used my interpretation of what those key qualities are, and perhaps with the caveat that you should understand that the statement of importance and interpretation of it is our interpretation. I believe that the statements that both she and I have used are our interpretation of the reasons for which it is designated, because they are not set out in as many words.
I'll invite you to come back then, because there was obviously a suggestion, an assumption about the judgment that you've made as well. So I'll allow you to respond to that and any other matters that you wanted to pick up.
Yes, I would agree that there is a level of interpretation because as opposed to some other designation statements where you might find bullet pointed lists of the special qualities, In this case, it's a descriptive paragraph, and we've had to extract from that what we believe the key qualities of the Lambmuir Hills SLA might be. I would agree that there are some which are more descriptive, some which are geographically located, and I think there are some differences between us in terms of judgments as to what those key characteristics are. I think, for example, I included the remote and wild qualities as a key characteristic, where I think Ms Dower considers that that is a quality which is linked more generalistically. So there are some points where we have disagreements on what those key qualities which should be assessed might be.
And in your opinion, are those matters that I can pick up from your respective material that's been submitted? I would be well able to understand those distinctions.
I think so. I've listed key qualities in a sort of bullet pointed nature, so you should be able to see those on the list. And then I've discussed there were 3 key qualities which I listed as being affected, which will be the striking conical Dirrington laws, which we both agree on, also the remote wild qualities, and I also included the Southern Upland Way, which I do agree may not be considered a key quality, but maybe more about the appreciation of the SLA.
Okay, was there any more, or I'll let you do that.
No, I think I'm content that there's interpretations, and with the evidence is in the documents before you.
Okay, anything more to say on B before we move on to C? Anything more for you?
No, I'm happy to move on.
And did you want to say any more before we move on?
I'm content also.
Okay, so we move on to then part C. So is the applicant's hearing statement correct that it is the impacts of the proposal on the Dirrington laws part of the special landscape area that is the point of disagreement between the applicant, the council and other parties? And if not, what other reasons for designation would be affected? We may have just started touching on this a moment or two ago, so I'll let you explain your response to that.
Yes, I think we were veering into this one. So I would say that the areas or the points of disagreement would be the number of special landscape qualities affected. So I have listed, as I say, 3 with consideration that Southern Upland Way may be considered more of a way to appreciate the SLA than a quality.
And that was one of the 3, was it?
One of the 3. So the key ones to take forward would be the striking conical Dirrington laws and the remote and wild qualities. And it's the remote and wild qualities one which is not picked up by the I've assessed major effects reaching to 9.5 kilometres into the SLA area, which is a high degree of adverse effect to find in a special landscape area. And also consider that the effects are not confined to just the south-east portion, as the applicant describes, but it reaches into the core area. The applicant describes a relatively small portion being affected, and I think that doesn't represent the actual impacts on the ground.
So your feeling is that the impacts and effects of the proposal would be felt much further, presumably north, or certainly further into the special landscape area?
Yeah, so I don't know whether it's worth, I've got one of my figures which shows graphically whether it's...
I'm happy for you to refer to that, and we'll give everybody a second to find it. Do you want to tell us which one it is? And we'll...
So it is, just find that one. I've called it figure 5, and the key reference would be, let me just find that.
It's 13.004. I think.
13.004. If it's one that anybody at the back wants to look at, this might be one that's on the laptops. In fact, if the participants are happy, I've got a paper copy of it which I can pass down to the back so people who want to look at it can, because I have an electronic copy. Are any participants I take it there's nobody who's concerned about that. That's fine.
So 13.004 for the council, and then it appears again as 14.033. But in effect, they're identical.
Yes.
So it's the same document, but because you had two clients, each one has had it submitted, so there's the same document twice with different references. Okay, just a moment then. I'm going to just, if no one objects, David's just going to pass. I'll just make sure I'm showing the right one.
Yes, that's
Right,
the one.
okay. David is going to go put this on the table, so if anybody at the back who's watching the public gallery wants to have a look at that, they can. I'm going to look at my electronic copy on here. Has everyone had a chance to get that in front of them? Okay. Yeah, I've got the electronic copy in front of me. So I showed that a few minutes ago. So there's a yellow area to the top, which is, well, in fact, why don't you tell me what it is I'm looking at, and then and hopefully everybody else can have a chance to follow that as well.
Yeah, certainly. So this illustration shows where the significant effects are located. So everything that you see on there, pink lines, blue dots, etc., are significant effects. The site is shown, there's a, I guess you could call it a sort of a pink shaded area it's quite central to the plan. And there's a large shaded yellow area bordered by a brown boundary, and that is the Lammermuir Hills SLA area. So I just wanted to show how you can see that the Lammermuir Hills SLA kind of comes along east to west, and then there's a portion which sticks out to the south, which is the area with the Dirrington laws in it. Within the applicant assessment, it is this area which is considered to be the area that's affected.
And if I can just interrupt you a second, would the point where it says 13, there's a green spot and it says 13, is that Dirrington Great Law? Is that
Yes.
VP 13?
Yes. That's correct.
So I suppose for anybody who's following at the back, if you can see that, then that gives you a sense of where Dirrington laws are. Sorry, I interrupted you.
No, that's fine. Yes, so point 13 is Dirrington Great Law, and just to the southwest of that would be Dirrington Smaller Law. I've lost the name of it.
Dirrington Little Law, I understand.
Little Law.
And is it fair to say
Apologies.
there is just to I suppose the left of point 13 there's a triangular, slightly wobbly triangle pink hatching. And
Yes.
if I was to go down what is the left-hand side of that, there's like an X. And the top left-hand side of the X, is that the path that leads to the top of Dirrington Little Law?
It is,
So-
yes.
Okay,
yes.
so I can identify from this map both of the Dirrington laws, so I can see where those are. Sorry, on you go.
No, that's good. So, yes, you can see that the area where you've just identified the Dirrington laws is the sort of southern portion of the Lammermuir Hills SLA, and I think it's this area that the applicant is referring to as being affected and is referred to as the relatively small portion. But if you look up to where there's point 16, which is the northernmost circle, this represents viewpoint 16 at Runt Law, which is considered significantly affected, and I've assessed as encountering major levels of effects. That reaches into the central area and into the core of the SLA area, and I would suggest that I judge that to be a greater level of effect and a greater geographical extent. Similarly to the left-hand side, at viewpoint 15, which is towards the southern boundary of the SLA area. This is along the Southern Upland Way, and this is Twin Low Cairns, and the viewpoint there. I've assessed this as encountering major adverse effects as well, and this extends beyond that southeast portion of the SLA area.
And for both viewpoint 15 and viewpoint 16, you were telling me that your assessment of effect. So is that a different conclusion you've reached to the one you see the applicant as having reached for both those? And that's for the viewpoints, or is it for the thing I wanted to understand was whether because I think you've written there's a if you look at viewpoint 15 to the right hand side of that, so to the east, is a purple area along what I think might be the Southern Upland Way, and I think your key says further significant effects identified.
Sorry, that's the west, not east.
No, the east.
Heading, if I'm starting at viewpoint 15 and heading that way,
Sorry, you're starting at 15.
yes,
I beg
yes,
your
yes. I think Mr. Campbell might have been starting at the other end, so I think we're both talking about the same place. So, could you just explain to me what further significant effects means? Does that mean beyond what the applicant had concluded, or did you mean something else?
No, that's correct. So those were beyond those concluded by the applicant. However, that particular section was amended within Ms. Dower's hearing statement to say that the applicant does in fact consider that section to be significantly adversely affected as well.
And well, do you want to finish what you were saying about that part? Because I was going to ask you about the other purple bits, but I don't want to take you away if you were needing to make some other points before we get to those.
No, I think that was, I think I concluded the discussion about the geographical extent with that.
So presumably then so if we go a little further to the right, so there's a white label there which says Longformicus, and just beneath that there are two sections of purple line on the red hatching. I understand the red hatching to be the Southern Upland Way. So there's two sections there. So again, is this you're finding further significant effects, so therefore are you concluding a higher level of effect in those places than the applicant appeared to do so?
Yes, that's correct. So the effects on the Southern Upland Way I conclude to extend to the east of Longformicus. Longformicus, apologies to everyone locally. The applicant has not assessed any significant effects to the east of Longformicus. So those are additional over and above the LVIA assessment.
And can you just talk me through your rationale for reaching that conclusion? I note that you'd said with the previous one in relation to 15 that the applicant had revised in its hearing step, so there appears to be agreement. I'll obviously let you come back afterwards. So can you just talk me through the rationale for that one, please?
So to the east of Longformicus, the development is hidden as you move through the residential area, but as you progress along past Caldra Farm, the Dirrington laws become visible again. There are no visualisations taken from this side, so I've had to judge this based on the maps and taking bearings as I've moved along. But
and sorry, when you refer to the maps, I take it is that the zone of theoretical visibility maps?
Yes, yes. So the zone of theoretical visibility shows visibility recommencing at this point, and certainly when you're on the path, the hills are very visible and obvious, and they reappear, and the turbines would be sited to the side of those. So it's quite easy to conclude that the views would recommence at that point. You would lose them again as you move further on, and then they would open out as you rise up the hill towards Black Hill Wind Farm. The proposals will be visible as an extension of Black Hill Wind Farm at this point, and within my assessment, part of the combination of the increase of the lateral extent of Black Hill Wind Farm and a greater expanse of wind farm influence in the horizon, as well as the juxtaposition of the scale of the proposed turbines at Lees Hill against the Black Hill turbines, were part of my reasoning for a medium level of effect and a moderate and significant adverse effect at that point.
So, judging, so one question. Obviously, you'd used the zone of theoretical visibility maps, and forgive me, you'll hopefully be able to correct me. Are those the ones that are showing tip height, or are those ones showing hub or something else?
So the hub height maps are the ones that I would generally use because it gives a better indication of the greater extent of the turbines visible.
So your judgment here is based on hub height?
Yes, that's correct.
So if I can take you to the smallest of the two, so the left hand of the two purple lines, so the one underneath Longformicus, my apologies. So I think you'd mentioned to me that the Dirrington laws would come into view at that point. So I'm just looking at this map. So if I was standing there and looking in the direction of the proposal, I would see towards the proposal, and Dirrington Great Law would be here to. Forgive my directions. I'm trying to look at you while the map's the other way around. My Duke of Edinburgh teachings have not paid off for me on this occasion. But so yeah, so I would see to my right Dirrington Great Law, and I would see the proposal either straight on or slightly to the left, according to this. Is that correct?
Yes, that would be correct.
So I would see them both in the same view, but they would not appear to me to be together, if you like. There would be distance between them. Is that a fair understanding?
That's my understanding from reading the ZTVs, that they would appear as set aside, but within the same view and associated with the Black Hill wind turbines.
And this particular location, judging by your map, where that is, that effectively leads a person from, forgive me, I forget the name of the farm that you mentioned, but it would lead someone who is using this path from the farm that you mentioned. It appears right to the edge of the special landscape area boundary before the Southern Upland Way, and maybe a tiny bit north before the Southern Upland Way turns to the right, to the east, and then heads up to the second purple area. And the second purple area is not one that's within the special landscape area.
Yes, that's correct. So it's just the smaller portion which would be part of the special landscape area.
And therefore, just to clarify, then it is the smaller of the two that has informed your judgment about the special landscape area conclusions that you reach, and not the one that's just outside it.
Yes, so in terms of a greater expanse along the Southern Upland Way, it will be the smaller of those two. In terms of visual effects on the Southern Upland Way, we'll come to later perhaps, then the second one will come into play.
My question was really more because I think at the start you were saying to me that the information here had led you to the view that the impacts and effects on the special landscape area would be experienced further north than the applicant was arguing, so therefore north of the Dirrington laws. And I suppose I'm trying to understand, it is the smaller bit of purple on the right hand side which has informed that, and not the larger bit of purple which is further to the east, further to the right, because that's outside of the SLA.
Yes, that would be correct. The expansion in terms of effect on the Southern Upland Way would be the smaller purple line. But what I'm also saying is that I consider the effects which are felt at, say, viewpoint 16 and viewpoint 15 to represent an expansion beyond the descriptor used by the applicant of a relatively small extent and only affecting the southeast portion of the SLA.
Okay, I think I understand that. And just one more point of to make sure I've understood properly. So are the pink lines, as opposed to the purple ones, where you say significant effects on paths, significant effects on roads, are those areas where you see yourself as agreeing with the applicant's analysis and conclusions, or are these again areas where you take a different view? I realise that we'll be discussing some of these again, but obviously some of them are within the SLA, so I just wanted to make sure I understood what that meant.
So the pink ones are broadly where there's an agreement. To avoid overcomplicating the map, I haven't included, for instance, viewpoint 16 and 15 as a different colour. It might have been helpful, but there is a disagreement on level of effects there. But this is to show either significant or not significant, to keep it simpler.
And therefore, although we established this I think a few minutes ago, but just again so I'm clear, the purple lines are where you're saying the effect is greater than the applicant had argued. The pink lines, you're largely in agreement, and taking the point that you've just mentioned about viewpoints 15 and 16, you take a different view on those, and therefore the consequent effect on the SLA for the reasons that you've been talking about.
Yes, I would say that's correct. And broadly, the differences shown are significant versus non-significant effects.
Okay, were there any more points in relation to the SLA that you wanted to take us through for this before I invite the applicant to come back?
I think just to discuss the remote and wild qualities, which was the SLQ which I highlighted as being affected, which the applicant didn't highlight as being affected.
No, I was looking beyond you. No, quite all right. Okay, let's continue.
So this quality was scoped out in the technical appendix as not being relevant as a quality to be assessed. I think this is on the basis of, hold on, I think I've got here. Actually, it's discussed in the hearing statement that the development would be seen at the edge of the SLA rather than within it, and therefore that the remote wild qualities wouldn't be affected, and that the development will be in the context of the more settled landscape beyond the SLA, and therefore the remote wild qualities wouldn't be affected. I consider that the remote and wild qualities are very much a key characteristic and extend into the southeast portion. It's certainly described as in the perceptual qualities of the landscape character for that area as well, within the LCA 105 descriptor. The proposals, in particular the wind turbines, will be viewed within views which contain that area, within views from the Dirrington Great Law, within the public footpaths within the area, and within the roads through the area. And they will have direct impacts on the wild, expansive nature of that area. And so I considered that it does have an effect on those qualities, and it is a characteristic which expands into that portion of the SLA.
Okay. Anything further before I invite the applicant to come back?
I think that's good for now.
Okay. Probably a few things for you to get your teeth into. So if you want to just take your time and respond to the points that you feel necessary to, and when you've done that, we'll go back to and check if there's anything else, and then you get a chance to come back as well.
Certainly, sir. There are quite a few points there, so I'm not quite sure where to start, whether to start at the beginning or whether to start most recent.
Whatever you feel you want to tackle first, I'm quite happy to look at either.
Okay. I suppose, starting at the beginning, I think the answer to the first part of your question that on the agenda is that it is the implications of the identified effects on the Dirrington Laws area, part of the SLA, which I believe is the southeastern corner. That is the question for this designation. I do want to point out that many of the effects that Ms. Platt has been talking about are visual effects, and they're not landscape effects. She said just a moment ago that the extent of landscape effects would be greater than what has been assessed in the LVIA. I believe that's not the case. There's a statement of agreed matters that landscape effects would extend to a maximum of 6 kilometres from the site. That's LCT 105. That's 6 kilometres from the proposed turbines. The turbines are about 1 kilometre away from the boundary of the SLA, therefore extend about 5 kilometres into the SLA. I think there was certainly reference to around 11 kilometres into the SLA. That is visual effects. So I think the point about the small proportion of the SLA being affected, I'd like to take you to figure 6.6, if I may. That's document 1-230, section 1.
Is this one of the map visualizations?
It's in the first volume of the visualizations. It's the designations map.
Just bear with me a second, I'll go and find that. So figure 6.6, 130. I've got a paper copy here. Designation, right, 2 seconds, I'll grab that and bring that up if other people want to take a few moments to find it.
A couple of pages into the first volume of visualizations.
If you're wanting to follow at the back, I think
6.6.
one of the applicants' staff will be coming to help everybody just to find that as well. So let's all spend a moment just finding the map we want to find, and then when we're ready to go, we'll look at that.
I have it on screen, but
so I have in front of me figure 6.6, designated landscapes. And in the key, I can see proposed development site, turbine location, distance from turbines, 5 km intervals, other wind farms, existing construction, and then we've got national scenic area, special landscape area, East Lothian, special landscape area, Scottish Borders, Northumberland National Park, gardens and designed landscapes. And there's a ZTV for 1 to 2, 3 to 4, and 5 to 6 turbines. Am I looking at the correct document?
that's the correct figure.
Okay. And I think hopefully everybody who wants to have a look at the back is able to find it. Has everyone got the documents? Okay, so on you go.
Thank you. This figure I'm producing in order to demonstrate the extent of the SLA as a whole. If you can see the boundary that starts immediately west of the site but extends northwards until it gets into the yellow, that's East Lothian, and all the way westwards till it gets to the main road, the A6968 to Lauder. So it's a very extensive SLA. And therefore goes beyond the extent that's shown on figure 5 of Ms. Platt's evidence. We've also just been taken through significant effects on the Southern Upland Way. There are no further visual effects beyond that that have been identified by either party. But again, just to say that that's visual effects rather than landscape effects. And indeed, views are not mentioned in the descriptive statement in the SPG.
And that's the descriptive statement that we were talking about at point B a few minutes ago. Okay.
Do you wish me to talk about the Southern Upland Way at this point? Because it's been relevant.
It's been put to you, so I'm happy if you want to talk about it.
Okay,
particularly if you take a different view.
Just very briefly, the section east of Caldera Farm, the short purple section.
The little purple bit on the right-hand side to the east.
That is within the SLA and below the title of Longford-Mickes. Just to point out that if you are travelling eastwards, I think the Southern Upland Way is generally walked west to east. The Dirrington Great Law would be perpendicular but slightly behind you. Diddington Little Law is not visible from that section. And the proposed development would be seen also perpendicular to your route. Black Law is somewhat perpendicular but slightly ahead. And Crystal Rig Group, or part of the Crystal Rig, I think it's actually Aikengall, is visible to your north.
And I can see those coming on figure 6.6 that we've just been looking at.
Yes, the existing turbines represented by the little black dots.
Do you need to cover this bit?
Sorry, what am I?
In your notes. You haven't really. You haven't taken wildness and remoteness.
Apologies for a moment there. I want to now turn to the wild qualities. An assessment of wild land qualities was not included in the original LVIA because it is not part of Nature Scott's defined wildland areas, such that a wildland assessment formally is not required. Remote qualities are considered within the assessment of landscape character type 105, including the position of the turbines, the development at the edge of and in the context of subtle landscape. It's noted that we have agreed on the effects on landscape character type 105, which contains the Diddington laws and also the ESCAs that are south of the road that goes straight through the landscape character type. That area was not included in the SLA. I would also like to say that in paragraphs 9.4 and 9.5 of Ms Platt's evidence in behalf of the Council, she implies that the characteristics of remoteness and wild qualities would be lost completely, using terms such as abruptly concluding and fundamentally altering or removing qualities. I disagree with this. I find that some of those characteristics would be altered, and I've said so it's part of the assessment of landscape effects, but I disagree that they would be lost. If they were to be lost for the special landscape area because of the development, how can we say that they're present with existing wind farms, both present around and within the SLA? I think that covers all the points that I need to make.
You happy? Well, I'll let them respond, and you'll be able to come back if there's any points. So you've obviously heard that discussion. I can see that there's a degree of disagreement, and it's been explained to me there. Some things to do with visual versus landscape, and a few other matters that I suspect you might want to pick up. So I'll let you do that in whichever order you feel appropriate.
Yes, thank you. I would pick up first the note that I was discussing an expansion of landscape effects, and I agree that we are not discussing that there are broader landscape effects. That's within the statement of agreed matters. What I was referring to there would be the expansion of effects on the special landscape area rather than landscape effects. So in discussing the visual effects from, for example, viewpoint 15, Twin Law Cairns, there are visual effects there, and this is illustrated, but there are also effects on the key characteristics in terms of the interruption and interaction with the striking conical Diddington laws, for example. this is a characteristic which is in play when you're at that position. The Dirrington laws are evident within the lower landscape, within the more settled views towards a more settled area. And they are a landscape feature which is a repeated feature as you walk along the Southern Upland Way. They are very notable and they're present and they repeatedly come into view. And I think that the views towards them and the interaction with that quality is affected to that extent, which is where I'm suggesting that it extends further than the applicant has interpreted. The discussion, I'll move on to the discussion regarding the area which I've assessed as encountering further effects on the Southern Upland Way. Just to add in that the views along this section are pushed towards the south because you're bounded by quite a large hedgerow at this point. There wouldn't be any views towards Crystal River.
I'm sorry, which bit are we in?
Sorry, this is to the east of Longformacus. Sorry, Longformacus.
Are we on the small purple bit?
We're on the small purple bit,
Okay, understood.
yes.
It's good to use these scientific terms, isn't it? There we go. Okay.
Yes, so the views would be pushed towards the south at that point, and so perpendicular views would become more prominent than perhaps you would usually expect because of the screening to the north. Again, the prominence of the Dirrington laws is really a strong factor in drawing attention to the proposals because of seeing them as a repeated element within the landscape as you move along both the Southern Upland Way and your experience of being within the SLA area as well.
So, just going back to this, obviously, I don't know if you recall a few minutes ago before the applicant was responding in the previous session when we were discussing this, I was suggesting that were I to be looking south from that point, I think we agreed, didn't we, that I would see Dirrington Great Law on my right, and I would see ahead of me, or possibly slightly to my left, the proposed development, or at least parts of the turbines of the proposed development. And I'm just looking at the kind of positioning of the boundary on this map. So would I be looking along and out of the boundary of the SLA if I was looking at the proposed development?
Yes, so the development itself would be appearing out with the SLA, with the Dirrington laws obviously appearing within the SLA. So in terms of my assessment of the impacts on the SLA, it's the interaction with the development, with the hills, with the features of the Dirrington laws that's the key point.
Sorry, I interrupted you, so there were some other things I think you were going to go on and say, so I'll let you say those.
Yes, in terms of the discussion on the wild qualities, I would agree that there isn't a wild land assessment required. It's not been requested in scoping, but that because it appears as part of the key qualities for this landscape area, it is relevant for that to be considered as part of the assessment. And certainly my assessment has been that there is a greater impact and that there are severe effects from the proposals in terms of those wild qualities. I think obviously there is a consideration that there are existing wind farms within the Lammermuir Hills SLA, and there's no, I'm not suggesting that there is no possibility of wind farms existing in an area which is considered remote and wild. However, because of the extent of this area, it's quite small and it's quite contained. It's quite a small pocket of wildness, and it's the scale of the proposals against that small area of landscape which I felt has such a strong effect and strong impact on removing those wild qualities.
Okay, and just again, I suppose returning to the point, I'll let you address this because I'm looking at both maps, and I can see that I think we agreed a few minutes ago I will be looking at kind of along the edge towards the proposal. in your opinion, would I also see Black Hill wind farm, the existing wind farm, from the small bit of purple looking along the boundary? And if I would, is it the kind of, is it the further extension of that and the proposal that is for you what kind of tips this, or is it something else? I just want to understand a little bit more. Can you just explain that in a bit more detail for me?
Yes, my interpretation from looking at the proposed maps, the ZTV, and the other figures is that the proposals would be seen against Black Hill, that Black Hill is visible here, and that it would in effect expand Black Hill to the west, or to the right as you're looking at it from this viewpoint. And it's that expansion, but also the juxtaposition of the large turbines against the smaller turbines, which contribute to the effects, and also the interaction with the hills as well.
And is it that point then for you which diminishes a kind of you talked about the wild quality, so that concept of wildness? Is it that factor which diminishes that in this particular area for you?
No, in this particular area, it's the consideration is more about the striking conical Dirrington Law special quality rather than the wild qualities for this bit.
Did you want to say any more before I invite the applicant back?
No, that's good.
Okay, so there's perhaps a couple more things to pick up on, and I'll let you deal with them in whatever order you see fit.
Certainly, yes. Again, to just make the point that it's effect on the designation rather than on landscape and visual effects. So it's that extra bit of interpretation, so it's not just visual. On the subject of viewpoint 15, when you're up there, the views towards the Dirrington laws and the effects that the proposal would have on those Dirrington laws, you do, however, have a sense of it being over there. That's not a technical term, it's just a description. It's not here, it's there. There's other parts of the panorama that you do experience when you're walking up there and when you're up there. That perhaps.
And in your view, I mean, obviously, there's, I suppose, I take your point that you were making about visual effects, but I suppose you're looking at something, aren't you? And you're taking that in and looking at the landscape. As you kind of walk along that path, I'm looking at the map here because I can just see where it is. So where the purple is on figure 5, you turn off that metalled road and you walk up a steep gradient, and then it flattens out and you walk along towards the viewpoint 15 Twin Law Cairns, and you can see. I think we have a visualisation, don't we? But you can. We don't have to go to it unless you need to, and you can see both Dirrington laws, and you can see the proposal beyond them. And you see them, would I be correct, you see both of them in the same view, and I think it was your point that not only do you see that and it's a distance from where you are, but there's a panorama and various other things to look at from that location. Is that the point you were making to me?
Yes, that's correct. Yes, that's correct.
And therefore, and just looking again at the map and the positioning of things, you're looking through and over the southeast part of the SLA, you're looking through and over the Dirrington laws, past the proposal, and over the Merse and towards the Cheviots, presumably. And is your point there that there's quite a lot to see? And are you saying to me that the vastness of that has the effect of, you can correct this word if you want, I can't think of a better word, diminishing any impact or effect that might have on the SLA? Is that the point you're wanting me to take away, or is there something else?
Turn it off. Yes, I believe so, something like that. Certainly the experience of going up there, I think you described going eastwards, up the Metal Road from the east, from the Watchwater Reservoir, the way you described it. But if you're coming over from the west, you will have passed, had views of Fallago Rig and to the north, and be coming over to the Twin Law Cairns, and then looking onwards, which is eastwards, and slightly off your route, or rather to the east, is the Durrington Laws and the Black Hill wind farm, and, as you say, the whole of the Merse down to the Cheviot and so on. But as you're walking, you're looking all round you. Yes, okay, it's ahead primarily, but it's a walking route rather than a driving route, so you do tend to stop and look around and take in the whole of the experience, yes.
But you are looking over that particular part of the SLA, aren't you? And I know you're looking beyond and out of it, and although the proposal is outside of it, you're looking at that bit of the SLA with the proposal sitting behind or next to, however it appears to someone who's looking there. And I'm just wanting to make sure I've understood the rationale for the difference that you have versus the position of the Council and DLH SOS with regard to how the turbines are positioned, how they're viewed, and what effect that has on that part of the landscape versus your own position.
Yes, that is correct, that you're looking over that part of the landscape to the Durrington Lords and then the development beyond, yes.
And so the fact that it's beyond and outside, in your opinion, doesn't lead... Is it those factors that lead you to a conclusion that's different from the other parties?
Yes, it is. Yeah.
Did you want to say anything else? I'll invite them to come back with any further points and then you'll be able to finish.
Yes, if I may. It was regard again to the little section of the route. Little section of the route east of Calder Farm. Again, I think there is a hedgerow along there, but you can certainly see Aikengal turbines, or at least part of the Crystal Rig group. I don't know exactly which turbines they are. So yeah, if you go to the site, go to that section, you will be able to see them, and you will be able to see Black Law and Durrington Law. Durrington Great Law is visible, but as you're walking along, as I said before, it's slightly behind you, and it's not particularly prominent from that section. Although it does become more prominent as you climb the hill, which is outside the SLA.
Did you want to touch on any more before I go back to the other parties?
Yes, the other little point I wanted to make, Ms. Platt described the wild qualities as existing in that small area, pockets of wildness in the SLA. The area we're talking about between west of the Durrington Laws, between the viewpoint and Durrington Laws, is actually a fairly small part. And in terms of wildness, there are other places in the SLA that will also show wildness. It's not the only part of the SLA that shows some wildness characteristics.
Okay, if there's nothing further on that, I'll invite the other parties to come back, and I think we're probably getting towards a point where we're reaching the end of this, but we'll just see and make sure we're there. Was there any... You've had a chance to listen to that, so did you want to say anything?
I'm just aware of not wanting to labour the point. I say, in terms of viewpoint 15, I think we've been over quite a lot, but just to remind that this does form part of the Southern Lowland Way. It's an area where those views are experienced for a long duration, prolonged duration, in the direction of the development. We will come to this point later on, but this also represents part of the disruption of the existing patterning of wind farm placement it's a position where you can clearly see the step from wind farms within the broader upland landscape to being linked to the lowland landscape, and part of that juxtaposition against the normal patterning and part of the incongruous nature of the placement of the wind turbines associated to the lower landforms and to the more populated landscape does, in my opinion, draw the focus to them, or will draw the focus once the proposals are in place. Also to remember the solar panels, which are also an additional feature which we haven't discussed, but just to remind that they will be in place also. I think that's all I want to say in addition.
I'll let you come back if there's any points that you want to make. What I'm going to do in a few moments is once we've done that, because I have a strong feeling we've drifted through point D, but I'll let us pack this bit up and then we'll check that there's no additional points that people want to make in relation to point D. So we'll give people a chance to do that, because you might well have been waiting for me to get to that stage. So I'll let you make any further points you want to make with regard to these.
I think we've rather slid into cumulative matters. I don't know whether you want me to address that just now briefly, or we've got an item.
Certainly, if there's a quick point that you want to respond, I mean, we do have a section on it, and we will be discussing it. But if there's a point you need to address now, I'm happy for you to do it.
Yeah, this is the SLA. So yes, it's a pattern within. Perhaps making the point that there are wind farms within the SLA, there are wind farms around the SLA, and outside it. This is also going to be outside it. So, I'd also like to make the point that the solar panels have been assessed to 5 kilometres, and they're not visible from this viewpoint. Sorry, they're not visible from the viewpoint, but they don't. They're not so visible that they can contribute to significant effects very much.
Sorry, my fault, I misheard you. Just that last answer, did you say they're not visible, or they're not visible?
I confess I might go back to the visualisation just to double check the lie of land.
Yes, I'm happy for you to do that, and then you can clarify the point.
Sorry. I confirm that they will be theoretically just a little bit visible, as shown on viewpoint 15, but the extent of likely significant effects arising from the solar panels does not extend to the viewpoint.
Okay. Did anybody want to make any further points on C? I think we are well on our way to covering stuff that's in point D, but I think it's important that we do that. I noted Mr. Trunick has points that he wants to make on that. So we accepting what I don't want to do in the point D is repeat anything that we've just repeated, that we've just rehearsed. There won't be need to do that. I've got that. So under point D, what are the specific differences between the parties which lead them to conclude differently for the effects of the proposal on the special landscape area? I know we've gone into quite a few, but there might be some others that you need to touch on. So I'll invite the Council and DLH SOS to speak first on that, and then I'll let the applicant come back. So as I say, please don't go back over. I mean, I'm happy for you to just summarise or refer to points that you've already made, but I don't want to re-listen to what I've just listened to, because I've got that already.
Yes, thank you. I think it's more of a summary from my point of view. So the geographical extent, expansion being greater than the applicant assesses, and certainly from DLH SOS's point of view that this affects the SLA as a whole, that there are a greater number of SLQs affected than the determination from the applicant.
And by SLQs, you mean special landscape qualities?
Yes, I do, yes. That this impacts on the Southern Upland Way within the special landscape area, which is referenced directly within the designation statement, and affects users on the Hardens Hill Road, travellers, and the public rights of way as well within the area.
Any more?
No, that's good for now.
Okay, I'll let the applicant set out your position as well as responding to anything.
It's just an initial point. It's a difficult one. I don't want to disturb the even tenor of the hearing session, but you referred under matter C to the differences between BDAO and other parties, and 1D asks what are the specific differences between the parties. Well, we've got two parties represented by Calder Platt.
And I will allow them to clarify that matter. I mean, I think you made a distinction between a position, and I'll be happy to explore that a little further. We can do two things. Either you can pause and we can come back to you and we can allow them to do that, and then you can respond, or you can say any other bits you want to say, and we'll.
I'd rather say them and then. Because for DLH SOS, Dunlees Hill SOS. By the way, I'm not questioning Calder's professionalism. I know she's a true professional. I met her before, and she's good. But for Dunlees Hill SOS in paragraph 3.6 of the hearing statement, we have a specific contention that there would be impacts on the integrity of the SLA as a whole. And those points are repeated in paragraphs 12.2 and 12.8. Whereas for Scottish Borders Council, we have no contentions about integrity at all. In 4.6, significant effects on the Inland SLA, affecting the southern and central portion. But in 4.6 and 13.2 and 13.8, there's no contention about integrity. And whereas we did raise this before the inquiry at this point, and if this was an inquiry session, I wouldn't worry so much, because Calder Platt would be giving evidence for one party, then for another, and I know exactly what the cases were. But in the hearing session, we had to be really careful we don't get muddled between the case for different parties. And I am a little bit muddled. In the reason for objection relating to designated areas, SBC do mention policy 4 of MPF 4. But that of itself is not enough, because policy 4, which is written very oddly, frankly, but it's written the way it is, we have to deal with it. You may affect integrity, or you may affect the qualities for which the area has been designated falling short of an effect on integrity. And it matters in terms of the limb 2 of the policy and what you do on integrity. So it does matter to know. Now, if the position of Scottish Borders Council has somewhat expanded beyond that set out by the Landscape Officer in her consultation response paragraph, which is document 1231, electronic page 6, where there's no mention of integrity at all, then I had to accept that. We're in the inquiry, I'm not going to make a fuss about it, but I need to know whether Scottish Borders Council now contend an effect on integrity which they've not done before. Now, obviously, Calder Platt can only give one professional view. You can't say, well, my view for one party is this and my professional view for another party is that. There's only one professional view she can give. So I need some clarity here from Scottish Borders Council as to whether they, on the evidence of Calder Platt, are maintaining an effect on integrity or an effect on special qualities falling short of an effect on integrity. It matters when it comes to policy. We have to know. So that's my... By the way, this concern repeats itself, but I won't dwell on it now. for RVAA and for aviation lighting, but we've got differences between the parties. Now, I'm not criticising you at all. You're in a difficult position, I can see that. But I would like clarity on this point.
You did mention that each of the parties had a slightly different position, and you did mention that point about integrity. I think the points that Mr. Trunick raises, I think, invites us to at least explore those matters, and it would be helpful to understand that distinction. First of all, whether it is as Mr. Trunick says it is, and secondly, the rationale for that, so that we can at least have an understanding of, if the parties have different positions on particular matters, we can actually understand the nature of what that is and the rationale for it. So do you want to say a bit about each of those? Well, first of all, you can address the points, but I'd very much like to understand, as I say, unpack it in two bits. Is the distinction of that nature, and then if you can talk about the rationale for it.
Yes, I'm happy to do that, and I do appreciate it's an awkward or slightly confusing position at times. So I can be very clear from the council's position. There is not an overall effect on integrity. My professional opinion supporting DLH SOS is that it does extend to the integrity, but of course within the council it's a judgment and a balance of decisions between my assessment and the previous landscape architect's assessment and the judgment of the planning officer, which is where the difference in opinion presents itself.
So your professional opinion is that the integrity of the SLA would be compromised in the manner that DLH SOS is arguing, and the position of the council was not and remains not as strong as that.
Yes, I think that explains it quite neatly.
Did you want to say any more before I invite the applicant back?
No, that's fine.
Mr. Trunick.
Clear answer, much appreciated.
Were there any further points on D that you wanted to explore, Ms. Dow?
Thank you. Yeah, again, Ms. Platt provided a little summary. I just want to pick a couple of points in that. Just pointing out that there are an increased number of turbines and wind farms being built within and around the SLA since its 2012 description. That's one point I want to make. And then the Southern Upland Way is certainly a very good way of experiencing it, and it's popular with walkers. That I certainly don't disagree with. But it's not a reason for designation. There are many sections of the Southern Upland Way that are passed through undesignated landscapes. And also like to point out that it is 344 kilometres long. Rather than just the short section that we've been discussing so far. So yeah, as part of the overall experience, and even if you only walk a small section of it, you're aware that it's a long distance route. And in summary, in assessing whether or not the description of the SLA would be affected, I do think that there would be some changes as set out in my assessments, but I don't think the proposal would prevent an understanding or appreciation of the area as a whole or as a small part, nor its attributes. And I don't think it would alter the area to the point where some part of it would not be redesignated if the boundary was to be redrawn. So I don't think the Durham Law's part of the SLA would be omitted in the event that if the proposed development was present, the boundary were to be reconsidered.
So I want to add one point to that, we are still reliant on the 2012 description. That is the citation for the SLA. When that statement was written, Crystal Rig 1 and 2, Black Hill and Dun Law were operational. The Aikengall 1 just
I'm sorry, can you just slow down and repeat those? So
yeah,
I can get
sorry.
a note?
Crystal Rig 1 and 2, Black Hill and Dun Law and its extension, in fact, were operational within the SLA. Aiken 1 was operational just outside the SLA, and Falago Rig had been consented but not built. Now, the Scottish Builders Council has a fairly new LDP. It could have revisited the issue of the SLA and its boundaries as part of the review of the LDP. It did not do so. It simply rolled forward the 2012 description of the qualities, or whatever they're supposed to be. It did not do so. I think you need to bear that in mind when looking at the 2012 document and how far it now truly represents a proper description of the qualities of the SLA, given the development which has taken, the wind farm development which has taken place since that date.
Okay, thank you for that. I'll let the other parties come back, and then we'll see where we are. We might well be at a stage where we can close. Do you want to respond to those points?
Just a brief one, just to describe really the atmosphere in this area, the southeast and central portion of the SLA. There are extensive wind farms within the SLA area. There are areas where it is a wind farm landscape in close proximity to those. However, when you travel along the Hardens Hill Road from Gifford over towards Duns, the experience is not of a heavily wind farm influenced landscape, and this would change with the development in terms of the proximity to the road and the experience of being nearby large wind farm resource. So I think there's a distinction between, yes, there are wind farms existing and it does change the SLA and the nature of some of the areas. However, this area is not one currently heavily influenced with wind farms.
And any more? Is that all?
No, that's fine.
What I'll do is allow the applicant to respond, and then you can close overall on matter one if you want to, assuming there's nothing further to go on matter one. The applicant then, so you can respond to that, and then if you want to say anything by way of...
I want to say and no closing.
Very well, okay, thank you all. That brings us to the end of matter one. I'm just looking at the time, that's just coming up to 11:40, and this might be an apt moment for us to take a breather, get everyone a comfort break. It had been mentioned about having a slightly extended break because I think you wanted to speak to the other parties. How long do you think you would need for that? Bearing in mind you probably want to take a little break yourselves, and how long do you want to adjourn for?
Give us half an hour and we'll report back, but half an hour should be enough. Either we're going to reach or not.
There is a small room just off of there. Would you like to go there, or would you like me to go there so you can speak in here?
I think they'll freeze in there.
Sorry, no, the small room to the side.
Oh, I see.
If
We'll
you,
go and freeze. Yeah.
I don't think it's like I'm happy to freeze. I'll let you all go and sit in that room in a minute and what have you. For everybody else, there's toilets just through there. Do please remember there is an access ramp that's just placed on the steps, which we may be helping with shortly. So half an hour from now, so that's 11:40. Please be back for 12:10. if everyone can just take a seat, please, that would be good. We have, yeah. Welcome back, everybody. A little bit longer than we were anticipating, because I understand we'd taken a longer break there to allow some of the parties to just have a discussion amongst themselves. So I think my first question is, do you need longer, or have you reached the conclusions or got to where you needed to get to?
There's a puff of grey smoke rather than white smoke, but I'm nearly there. The position is that I'm persuaded that there are accuracy issues in one or two of the renderings, three of the renderings actually, which I just need to check with the photographer, who is not Miss Platt, and I can do that over the lunch break. I think I know the answer I'm going to get, and that will result in an application to you to withdraw certain documents from the body of evidence.
And we'll know about that by the time we get to those points on the agenda in all.
Absolutely, yeah.
That then brings me on to, I think,
I think that's, if I may say so, that's the easiest way to deal with it. Otherwise, we hold up the inquiry discussing the remaining points. This is not a peripheral issue, it's an important issue, but it's peripheral in the sense that it interrupts the agenda. I'd like to see, I'm sure you would like to see that.
Okay, I think I understand that. Timing-wise, we are now looking at just coming up to 12:20. I'd looked initially to take a break for lunch about 1. We've got matters 2, 3 and 4. Matter 2 possibly has some length to it. I'm just going to take soundings on everyone about what you want to do. Do you want to take a slightly shorter lunch break of perhaps 45 minutes and go now and then come back and we'll use the rest of the time to go through everything? Do you want to start matter 2 and have the possibility of us breaking part way through it? There might be some bits of it we can get through relatively tidily before 1 o'clock, possibly. I'll take views on that. So, Mr. Trinny.
I'd rather break at 1 and make progress before then.
I would agree.
And Mr.
I
Campbell.
would agree with that, and if possible, we could sit at the end of the day a little longer, if we're within sight of a logical conclusion.
I'll certainly take soundings during the afternoon because we are in control of the space. That sounds quite powerful, doesn't it? I'll say that again. We've got the keys. So if we get through the afternoon and we need a little bit longer, there's no constraint on us staying a little bit longer, besides people's travel arrangements and other commitments. So we can take some soundings on that later this afternoon. All right then. Right, we'll progress with matter 2. So I'll read through as before the points on the agenda. We'll address these and we'll see where we've got to by nearer 1 o'clock, and we'll take a break for lunch at hopefully a logical stage there. So matter 2 is visual impacts and effects. Environmental Impact Assessment Report, Chapter 6, Table 6.4, omits Viewpoint 17, which is Coburn's Law, and Viewpoint 18, A6105 Churnside. These are covered in the Environmental Impact Assessment Report, Technical Appendix 6.3, where both are found to experience minor, not significant effects. So my question for, I think, the applicant first is, Part A, is this therefore a typing error, unintentional omission, or was there a particular reason for this?
It is indeed an error, I'm sorry. Tables 6.4 on pages 16 and 18 of the EIA Chapter 6 is entitled Summary of Significant Effects, significant visual effects even. Is therefore intended to be a summary of visual effects carried forward from the table of all visual effects that was set out in Technical Appendix 6.3. But the culling of not significant effects was incomplete, and the table is therefore more of a repeat than was perhaps intended. In other words, there was a reason for the omission of the 2 viewpoints, but somewhat undermined by incomplete editing. And so some of the other not significant effects were not removed, other viewpoints and routes, for example. So I do apologise for the confusion. I would also perhaps note that the entry for the core path on Duns Wood, through Duns Wood on page 18 is listed as not significant moderate, which is an error and should be not significant negligible. It is correct in Technical Appendix 6.3 and in the summary table in that appendix also.
And I have the technical appendix, and the technical appendix forms part of the environmental impact assessment report, does it not?
You do have them, yes.
Okay, I understand what you've just told me. I will allow the other parties just to respond on that if they want to.
No, I'm happy with that.
Okay, thank you very much. So that's nothing more to say? Okay, so that moves us on to part B. Dunseys Hill SOS initially opposed the environmental impact assessment report findings for visual effects. I've written here in relation to Duns, Gavington, Hume Castle, Polwarth and Restrother, and you'll be able to tell me whether I've got all of the correct ones there. In part because this was because it opposed the different effects concluded by the environmental impact assessment report for settlements versus specific viewpoints in or near to them. So part B, given that DLH SOS has provided a recent assessment of its own, which, if any of these positions, has changed. So firstly, I'm happy for you to tell me if I've got that right or wrong, and for you to clarify matters as you see fit.
Yes, I think the change there relates to my coming on board with DLH SOS. Originally, there were considerations that there were additional impacts on settlements, but within my assessment, I concluded that that was not the case in my professional opinion. There are significant adverse effects on viewpoints nearby, but within the settlements themselves, the houses are relatively inward facing and don't necessarily gain views towards the development. This doesn't mean that the access to and from them isn't affected. Obviously, the impacts on roads are clear within the assessment, but not on the settlements themselves.
I think Mr. Whitfield might have something to add to that evidence, if I may.
Dunseys Hill at that point were reflecting the views of the members of the group. So.
There we go. Thank you for that. I'd recalled, I think, that there had been a response to the group from the applicant. I believe in early 2025 it might have been, and I'd understood that they had explained its position on those matters, and I think this was just about tidying that up to understand where you were coming from. I think you've clarified it. Did you want to say any more before I invite them to come back?
No, that's all from me.
So I'll let the applicant come back if you want to on any of those points.
No further comment.
Okay, thank you. So that moves us on to parts C, D and E. So I'll just read those for the benefit of everybody following. So the key differences between the council's and DLH SOS's respective positions and that of the environmental impact assessment report appear to relate to views from parts of the Southern Upland Way, including at VP 15 Twin Law Cairns and parts of Hardens Hill Road, including at VP 16 Runk Law. On the most recent evidence presented for the council and DLH SOS, this difference appears to be that those parties see the effects as being major significant, whereas the environmental impact assessment report finds them to be moderate significant. DLH SOS also presents a map, and that's the one that we've looked at earlier today, I think, which is figure 5, visual effects. That's what it's entitled. Someone can shout out for us shortly the core document reference if they wish, and which shows the locations where it finds major significant effects to arise and what it terms further significant effects. And I realise obviously we have had some discussion on that, so we can focus our answers perhaps on this. So my question at part C is, firstly, is this synopsis accurate? And if not, could you please advise what the correct position is? Followed by the parties will be asked to explain the rationale for their respective positions on these matters, and the parties will also be asked to say what practical differences they think would be consequent from their own position versus that of the opposing view. I think it's probably helpful just to try and condense those, because I suspect in answering the points made in the latter ones might well be the case. So I'll invite the Council and DLHSOS to respond first, and then we'll hear from the applicant.
That's broadly correct in terms of your summary of the key differences. With addition, I've also determined moderate and significant effects for aviation lighting for nighttime effects on a portion of Hardens Hill Road. And Mr Trinick referred to this before in terms of the confusion perhaps between the Council and DLH SOS, because that doesn't appear in the Statement of Agreed Matters. It's the Council's position originally was that there are potentially significant adverse effects, but not of the level to become a matter for opposition, a matter for objection, hence not appearing in the Statement of Agreed Matters.
And did you say there that that was the effects of aviation lighting on Hardens Hill Road?
Yes, so for a small portion within the proximity to viewpoint 2 along Hardens Hill Road.
And I think you were saying to me, were you, that the Council's position on that and that of DLHSOS are distinct from each other? The Council, is it DLHSOS's position that it has concerns and its objection is predicated in part on that, whereas the Council's is not, even though it... Did I take it? Could you just explain that a bit?
Yes, certainly, and I might bring Kyle into this possibly just to clarify. It is within my hearing statement for both parties. However, it does not form part of the Statement of Agreed Matters, and my understanding is that it does not form such a concern that it becomes a matter for objection. Would that be?
Yeah, that's essentially correct. There was concerns raised. Yeah, there was some concerns raised by our previous landscape architect, but not of a level that we wanted to object to. And yeah, that didn't come through in the Council's position.
And I realise earlier on we discussed quite a lot with regard to Figure 5, the visual effects map. So I think I'm clear on the distinctions that you're making using the key of that document. Are there any matters with... I know you touched on this one, but obviously you were touching on the context of the SLA. So are there any matters here that you need or want to inform me of in relation to visual impacts and effects that you wanted to pick up from that, or in general, so that I can hear what they are and then ultimately the applicant can respond?
I think so. We go into the detail of those later on in the agenda. So I don't want to run through the ins and outs of the determinations. Are you looking for more of a summary of which ones have been picked up or not in this case?
I think I just wanted to make sure that we didn't ultimately leave matter 2. I think I'd said a few minutes ago I'd quite like you to cover both matter C and D and E as well. So what I didn't want to do was exclude you from doing that if you'd wanted to do that just now.
Okay, yeah, I understand. So you're right in terms of viewpoint 15. I think we've covered quite extensively, but in relation to the SLA, in terms of visual effects, I suppose broadly, just to go back to that, broadly there is an expansion of the higher levels of adverse visual effects to a further distance than the applicant concludes. So the expansion of major adverse effects to 9.5 kilometres is quite a significant change in terms of the level of effect and the distance that those effects are perceived at. I think, as you say, we've been around the map to show that the additional further adverse effects on the Southern Upland Way expand further to the east, to Longfall Acres, and we have discussed the small purple section but in terms of expansion and visual effects, that also includes the additional purple section, which is a little bit further to the east as well.
Yes, because for this particular part of the discussion, we're not constraining ourselves to the boundaries of the SLA. We're talking about visual effects in general. So, and you're telling me, I think, the furthest right purple section. For anybody who's wanting to follow, we're looking at the same map with the purple and pink lines on that we were before. So if people are wanting to follow on that, so and yeah, so you're talking about all of those more generally in this. So, okay, sorry, I interrupted you. Keep going.
So the visual effects, if I'm discussing the Southern Upland Way, which encompasses quite a few of the viewpoints anyway, the overall implications of the expansion are that a section which would be 12 kilometres long is interrupted and affected to significant levels for portions of a 12 kilometre section, which is quite a large expansion of the applicant assessment. If I'm looking, it might be useful just to look at that section or discuss the furthest easternmost section while we're on this part. Again, there are no visualisations from this section, so my assessment is based on the ZTV, which shows visibility from that portion. This is to the east of Long Formacus.
So this is the slightly longer purple line to the right-hand side, to the east of the Long Formacus white label.
Yeah, that's correct. So this is where you gain elevation. You're moving up onto the hills just below Black Hill Wind Farm, and before it sort of heads north, and you lose visibility. And along that section, the Dirringtons are to the southwest, and the experiences of being closely connected to Black Hill Wind Farm and is quite dominant within the views. However, the proposals will be visible from there, and they will be seen as an expansion of wind farm influence on the horizon. And again, one of my biggest concerns from this point was the juxtaposition of the scale of the proposed wind turbines against the smaller Black Hill wind turbines. Obviously, the Black Hill turbines are 78 metres, and the proposed Lees Hill turbines are 200 metres. And so I determined a medium, let me just check. It was a moderate and significant effect from that section.
What's the distance then?
I'd have to measure that, but it looks about 3.5 kilometres.
So if I look at the grid squares on there, assuming on this map a grid square, I'm assuming is a kilometre by kilometre on this map.
Yes.
Is that correct?
Yes,
so
that's correct.
if I was to loosely count the number of grid squares between the north boundary of the proposal and the grey line, we're looking. You said to me about 3.5 k's. Did you not?
I think, just looking at that from there, but I'd have to measure it to be sure.
Yes, I'm sure there would be an exact measurement that would be possible, but you're looking about that. So looking south from that section, I would see the proposal partly through, or certainly along the side, or the western profile side of Black Hill Wind Farm would look towards the Lees Hill proposal. Is that I know we touched on this earlier. Is that correct?
That's my understanding, and from visiting that point, it's my interpretation and using the plans as a guide is that you would see them connecting to and potentially, as you say, overlapping with some of the Black Hill wind turbines.
And is it that is the thing that's persuaded you of the conclusion you reach?
It's the expansion, the connection to Black Hill Wind Farm, and the contrast in scale, so that you have what appears to be quite an incongruous connection between the two wind farms. And again, there is also the added element of the interaction with the Dirrington laws. There is separation here, as you were discussing earlier. The Dirringtons would appear to the right-hand side, and there would be space between the hills and the wind farms, but it would still be within the same angle of view, the same panorama.
It's okay, you need to take instruction, what have you. Do we need to say more on that bit? Are there other things that you want to take me through?
Yeah, I'm just going through bit by bit. So to summarise with the Southern Upland Way, to wrap that one up, I think that the differences between myself for the council and the applicant are major and moderate effects as opposed to minor and moderate effects. Sorry, as opposed to moderate effects from the applicant, and an expansion geographically of those effects as well.
And that was your position solely for the council, because I think you just said...
That's for both.
That's for both, okay.
Yeah. In relation to, I'll just take these one by one. So in relation to viewpoint 15, there is a disagreement. The applicant determines a moderate and significant adverse effect, and I determine a major and significant adverse effect for both parties. That's in connection with the interruption of a prominent part of the view as seen from Twin Law Cairns. It might be useful to bring up the viewpoint at this point to discuss?
Yes, if you like. So we'll just give everyone a chance to find that. So could you just remind me of the... I know them by viewpoints, but others might know them by another description.
It's 001.253. It's figure 2.26.
2.26. This is one that's on the table at the back, and if anybody who wants to have a look. So just give me a second while I locate the right one. And is there any particular one of those that you, because I think there's usually A, B, C, aren't there? Is there a particular one of those that we're looking at?
I think if we look at the last one, which is E, probably the most helpful.
Figure 2.26E. Right,
Yeah.
just give me a moment while I find that.
It's in volume 1, if that helps.
Okay, I've got that. Has everybody else been able to find that? So I'm looking at a view looking what looks to be southeast, and it's a montage. So we've got a photographic representation of the proposed turbines themselves and the existing landscape. Is that correct?
Right.
This is the one that I've got. So is that right? This is the one that I think everybody should be looking at. It was right at the back, so okay, whenever you're ready.
Okay, so I mean, as I say, we've discussed this quite a lot this morning, so I won't take too long, but just to remind us that this is from the top of Twin Law Cairns. It's quite a broad summit. You've got the features of the cairns, the stacks themselves at the top. It forms a resting point or a destination point on the Southern Upland Way. It's quite well known. And the experience here is of being towards the edge of the Lammermuir Hills, towards the edge of the moorland, and with the lowland landscape stretching out to the side to the south. There is some wind farm influence existing. From this point we can see Black Hill, but there is also wind farm influence to the rear. And The key focus, one of the key focuses is of the Eldon Hills, which aren't within this portion of the panorama, but if you panned to the right from this angle, then they would be seen as quite prominent features within the landscape. But I would also say that the Dirrington Law Hills, as you see them within this panorama, are also a very prominent part of the scene, of the wider panorama, and certainly are quite notable and become quite distinctive elements as you move to the east from this point.
And excuse me a minute, and to make sure that I've properly understood, so we can see the 6 turbines of the proposal towards the centre. On the right-hand side grouping, there are 3, and there's a hill which appears, the left-hand side of the hill appears to be a darker colour than the right-hand side of the hill. And is that Dirrington Little Law?
Yes, yes.
Okay, and then to the left, beyond the furthest left large turbine, following the horizon, there is then what appears to be a TV mast, perhaps on a hill. And if I come slightly left of that, there's a hill there which appears to have some stripes down it on the left-hand side. Is that Dirrington Great Law?
Yes, that's
okay.
Right.
So I can position both of the Dirrington laws in relation to the proposal. So sorry, on you go.
Yes, so as you say, both of the Dirrington laws are visible from this viewpoint, and the proposals will be seen sited behind Dirrington Little Law and to the side of Dirrington Great Law. The prominence of the proposals, I felt, was quite well defined within the view. The fact that they're sited in the direct line of sight with the Dirringtons, and the fact that they appear out of place within the wider setting of what you've experienced within the wider view in terms of the wind farm influence. This led me to feel that they were quite a prominent and notable element of the view, and that they do change the balance of the view in terms of their interaction with that key feature, which leads to a high level of magnitude and the major effects which I determined.
And it's the magnitude of change is the point of contention between you that leads you to a different
Yes.
outcome, I suppose.
Yes, that's correct.
The coast as well.
Do you want to continue?
There's just a broader comment of views towards the Cheviots and the coast, but it's not picked up in my report, so I don't know if I can add that in at this stage. But I'm happy to leave that there and move on to viewpoint 16. I'll find the reference.
Viewpoint 16, this will be Runk Law, and I think that is the very last one in that folder, so that will be a few pages on. So
That's and it's key foundation document 001.254.
in fact, the place where I've just been on figure 6.26E, it should be the following page from that, which takes us to that for anyone who's wanting to follow. Just give me a second, I'll find that. Did you say which one? Was it A, B, C, D?
I think if we look at the last one again, which is the photo montage, and that is D in this case.
Okay, I've got that as the very last page in that particular folder, so if anyone's having difficulty finding that. Okay, so on you go.
So this is viewpoint 16 at Runklaw. This is along the Hardens Hill Road, and this is looking towards the south east. This is experienced as you round the corner. The views open up at this point to the Dirrington Laws. This is Dirrington Greater Law that you can see quite prominently to the right hand side of the view there, rising up. And as you come around the corner, it is It's quite prominent within the view. It's probably the main, well, I would suggest it's the main focus of this view, and I've assessed it as such. I have determined that the sensitivity of this viewpoint would potentially be higher than the applicant assesses, likely to be a medium high rather than a medium due to the broader than local use of tourists, and it's quite a well used cycle route in the area. The proposals appear to the side of Durrington Greater Law, and the scale of them is almost to the same vertical extent as the hill form. I felt that the proposals compete with that vertical extent, and there are challenges within the understanding of the scale of the hill due to comparisons of the turbines set against the hill. I assessed this as a high magnitude of change for a fundamental change to the nature and the focus of the view and the interaction with those existing features. This view is experienced for a relatively long duration, with the road travelling towards the south, towards the southeast, and it's quite a straight road, and this view will be the dominant focus within a long section of that view. My determination was of a major adverse effect from this viewpoint and for that section of Hardens Hill Road. That's all for viewpoint 16. The next disagreement is with the aviation lighting, with the nighttime effects. I realised that earlier I suggested that it was around viewpoint 2, and I'm just wondering whether I was correct there. I think I am, so it might be worth bringing up viewpoint 2.
So this one will be a night sky. Is that the correct one?
Yes, that's correct.
Okay, on you go.
So this is viewpoint 2, and it's looking towards the west or to the northwest, actually directly towards the west and perhaps the southwest, looking at my plan, from Hardens Hill Road as it passes the development. This section of the road, it's relatively elevated, and at this point you'll be looking across at the development with a fairly horizontal line of view, which is where the effects of the aviation lighting are experienced at their greatest because of the lack of shielding, which is employed as mitigation. This is described within the LVIA as similar to the brake lights of a car. It's very difficult to produce the visualisations to realistically portray the aviation lighting, but my assessment is that even if this was relatively similar to the brake lights of a car, you're looking over towards a very dark portion of the landscape in the evening, and that they would be notable and they would form a noticeable change. I assess that as a medium level of magnitude with moderate and significant adverse effects.
Sorry, could you repeat that last bit about your assessment? I didn't quite catch.
Yes, that was a medium magnitude with a moderate and adverse level of effect.
And was that moderate significant in your opinion?
Yes, it was. I do have some differences of opinion which relate to residential. Are they better relayed later on? They're not a visual effect as such.
I think, yeah, we'll deal with residential visual amenity under that heading. If you can give yourself a marker to make sure you remember to return to the points you wanted to make, then that'll be fine.
I think that's all of the ones I wanted to discuss. Thank you.
Okay, thank you for that. I'll just get this one out of the way. I'll just check through, make sure there's no points I have to make. I'm just looking at the time. We're coming up on 5 to 1, and I'm just wondering if this is an appropriate time to break, and then that would give the applicant the chance to have the floor straight after we come back. I realise we had a slightly longer break earlier, and I realise there's a little bit to get through this afternoon, so I wonder if we were to disappear at 5 to 12, which is in 2 minutes, when hopefully I've finished talking, then would we be okay coming back for 1:45? Is that all right? That's a slightly shorter lunch break, but I think I'd rather get through. You're happy? Yeah. Sorry, do you want to say something?
Just before we break, one point of clarification. Going back to nighttime effects, I think that you said the Scottish Borders position was that there would be significant effects, but they would not be unacceptable. I just recall that in the Statement of Agreed Matters agreed only last night, it says the parties agreed that no significant effects would occur on either landscape character or visual receptors as a result of aviation lighting. You've agreed that last night?
Yeah, I think from the council's perspective, yeah, we're not an objection to it at all.
Yeah, that's what I said. You can have a significant effect but not object. You have agreed in the Statement of Agreed Matters last night, no significant effects would arise. That's what it says.
Yeah, we accept that, what's been said.
So just thinking slightly earlier, where does that lead? So your position, can you tell me what your professional opinion is? Your professional opinion on that matter, the one that you've given me, and is that the position of DLH SOS first of all?
Yes, so my professional opinion is the one that I've just given, which is of moderate significant adverse effects. That's the opinion of DLH SOS, but on balance for the council, the agreement is that that's not the opinion.
So yes, so I understand that. So it's not the council's position, but it is your professional opinion, which is adopted by DLH SOS, but not by the council. Okay, so that is a distinction. Does that answer the? Well, I think I am clear. I am clear on the distinction that's been made.
Submissions. It's a bit of a mess, but there we are.
Right. Okay, that's brought us to just after 5:02. So can we be back? I've already forgotten what time I said. 1:45, please. So can we be back at 1:45, ready to go? Thank you. Well, good afternoon, everybody, and welcome back. That's just gone 13:45. There maybe some people who've popped out for lunch who might be joining us part way through, and that's fine. Before we left off, just before lunch, we were on Matter 2, Visual Impacts and Effects. We had got through parts A and B of that, and we were on parts C, D and E. And I'll just confirm, but as I understood before we went for lunch, the Council and Dunsleys Hill SOS had just completed setting out their position, and we were ready to hand over to the applicant to respond. I'll just check that I was correct.
Yes, that's correct.
Good. So over to the applicant, so you can set out your position in response to those points, and at the same time, if you wish, you can address the points that have been raised as well.
Certainly, thank you, sir. I believe we're on the matter 2C at the moment. And going back to that question, is the synopsis of the differences of the two... is your synopsis of the situation correct? Yes, I believe the synopsis in the first two sentences of your initial statement is correct. Ms Platt, just before lunch, introduced aviation lighting. And I would like to point out that I have set out the assessment of effects on lighting in my technical appendix 6.8. That's page 8 of that document. And the only point I would want to make is that the viewpoint is going to be experienced from within a car. One doesn't normally stand at that point. So it is normally to be viewed from cars where you would have views of lights on the dashboard and other vehicles potentially and so on, so without dark adaptation. That's all set out in my technical appendix.
And therefore, you wouldn't see the light.
And therefore, yes, the effects are not significant.
And what you just described to me from Technical Appendix 6.8, that is, it's those factors that lead you to that conclusion, as opposed to the ones that I was presented earlier with.
Yes, it's all set out there. Yeah. Yep. Sorry. The other part of that question is the synopsis correct? Just a couple of points on map 5, if I might take you back to map 5.
This is Ms Platt's map.
Yes,
is
that's
it?
correct.
Yes,
Sorry.
the one with the yellow area and with the purple and pink lines on it that we were looking at earlier. Yes, okay.
Just want to note there are a couple of errors with respect to the findings of the LVIA as recorded on that map. Firstly, it doesn't distinguish between major and moderate effects. That's just a side note. It does identify significant effects, so that's what I'm taking it as reading. The map is of limited extent. It doesn't go as far as viewpoint 20 at Hume Castle, which is south of the edge of that map. It's off the map. It also omits a 2-kilometre section of the B6460 between the A697 and Charterhole Woods, which I've identified as significant moderate effects on the visual experience of that route.
Can you give me that reference again?
Certainly, it's the B6460 between the A697 and Charterhole Woods. That's set out in my technical appendix 6.3 on page 35.
And could you just remind me there of the conclusion that you, I think,
It was
just told
moderate
me?
significant for that 2-kilometre section. And the map also includes a magenta line. It's quite difficult to find. The label on the B6456 at the southernmost corner of the SLA, if that helps. If you find the label, there's a hatched pink line north to south along that route. That was not identified, it was not considered in detail in the LVAA, because that path is out with 5 kilometres from the proposed development, which is agreed in the scoping report as being the extent for effects on local paths.
This is the hatched pink line that effectively transects the label B6456.
That's correct.
Okay. It crosses both sides of that road. It goes north and south.
Yes,
of
that's
it.
right.
Okay.
Yeah.
So
That's not an effect that's identified in the LBA. It's an additional line.
And the reason for that, I think you said, was because it was in excess of 5 kilometres from the proposal.
That's correct. Yeah. And other than that, I would say that if I did produce a map like this, it would be very similar. So I'm otherwise happy with that map. So that's the conclusion of my answer to 2C.
My understanding was that Ms Platt had dealt with matters under D&E as well in her matters earlier, and I'm happy for you to respond. I'll just confirm that that's the case.
I answered for matters under D, but perhaps didn't extend to E, which was the practical differences which would be consequent.
Well, let's focus on D and allow you to respond on B, and then you can come back, and that way we keep ourselves right. So I'm happy for you to respond to the points that were raised under D, give me your position and respond to those as well.
Thank you. So yes, with respect to viewpoint 15 and the southern Upton Way, the sensitivity is agreed to be high. The effect is agreed to be significant, although the parties disagree between moderate and major. As set out in my technical appendix 6.3 and my hearing statement, there will be panoramic views, including numerous existing wind farms, and in fact we went to the photo montage earlier. It might be worth going to the wire lines of that figure also.
Could you give us the reference for that one, please? This was viewpoint 15.
I think it's document 1253.
And there was a figure number, and it might be A, B, C, D, something like that.
Potentially all of them.
Okay, right, just bear with me a moment.
Sorry, I've
Gone too far.
I'll get those. I think it was at the very near the back of the first document, so just a moment.
Thank you. Yes, I'm drawing attention to the wire lines in figures A, B, C and D, I think, which...
Will I need them all at once?
You can flick through them, it's fine. Okay. It's more about just saying that there are numerous wind farms visible from that point, as illustrated by the wire lines. So, yeah. Falago rig is perhaps the closest. That is shown on figure B.
And would I be right? Is there an overlap here with A? Is some of A repeated on B, or do I need to
No,
put
there
them next
should
to
be
each
a
other?
direct juxtaposition.
Okay.
And we go on through C and D with other wind farms visible.
Well,
that's fine.
D now is a repeater. It just...
So having taken you through the full 360, the proposed development is clearly in one direction and does not affect the views in other directions. So it is a part of the full 360 panorama. It is indeed in the direction of Durrington laws. I would note that the Durrington Great Law lies pretty much below the horizon. It's not actually terribly prominent when you're there, whereas Durrington Little Law almost looks more prominent from that location. And in the photography on that figure E, if you like, the sun is catching the Black Law turbines, and they're quite visible in some certain light conditions, and in other light conditions they're not so visible. So the proposed development will be behind the Durrington laws. It will be partly behind Durrington Little Law, but seen very much beyond it. As I referred to before, you have a sense of distance between the viewpoint and the proposed development. You can see down the foreground and across the moorland, and they're beyond those hills. So there's certainly a sense of a distance. I have said in my assessment they may alter some perception of the hills for some viewers who may use them as scale indicators. So my overall finding is that it will be significant, but it's my professional judgment that the turbines will not affect the experience of the panorama as a whole to the extent of high magnitude of change and major effect.
Just to make sure I've not understood that, not misunderstood that last bit, because I think you said to me about major effect. Did I? Was it the counter opinion to yours that it was a major effect, and you were just telling me there you didn't think it was a major effect, or were you telling me something else?
I'm saying I do not think it's a major effect, and I believe it's the Council's position that it is. Sorry, do I go on? So the experience from the Southern Upland Way would be very similar at that point. For approximately 2 kilometres further down eastwards from Twinlaw, apologies.
Did you say eastwards from?
Sorry?
Did you say eastwards from?
Eastward, walking eastwards, which I gather is the normal direction in which it is walked. That is shown as the purple line on Ms. Platt's map 5. I do concur with that section.
So this is because I think Ms. Platt mentioned this morning that there was now agreement between you. So you are agreeing with the conclusion that is set out here that the purple line that runs eastwards from viewpoint 15, and Ms. Platt's conclusion that that is major significant effect on that part of the Southern Upland Way, and that is something you are in agreement with?
I'm agreeing that it is significant, but not that it is major.
So would your position be then it's moderate significant?
My position is that it's not significant. Sorry, it is significant but moderate.
I'm sorry, Mr. Campbell.
Just make sure I'm picking Miss Tower up properly. She said initially not major. Then I picked her up as saying not moderate, but I may have got that wrong.
I'm happy for you to just reiterate the point so that everyone's clear.
I judge that that section of the Southern Upland Way will have a significant moderate effect.
See, thank you. Thank you.
Yes.
My fault, I didn't hear you properly.
Continue.
Staying on the Southern Upland Way, going east of Longford Acres. Just a small point that, the section we're talking about east of Caldera Farm is very short. It's only about 400 metres, from what I can read from map 5 of Miss Platt's. And then the section up the shoulder of what I've called Owl Wood Hill, there's a bit of forestry at the top of the hill called Owl Wood, is somewhat longer, around 1 kilometre, perhaps just over 1 kilometre. From that section on Owl Wood, you are looking southwards past Blacklaw Wind Farm towards the proposed development. The larger turbines of the proposed development are further away, and due to perspective, they won't look much larger than those of Black Hill in that view, from that section. But they will rotate somewhat slower, so there may be a perception of the distance there. But I do not judge that those will be significant.
And presumably the reason for the slower rotation would be that they have a bigger. I'm sorry, I'm trying to remember my maths. They have a larger diameter.
They will have larger diameters, yes, and it's my understanding they rotate slower. Just to finish on the points with the Southern Upland Way, I do not find significant effects on the section just east of Caldera Farm, which is a little short bit of purple within the SLA on map 5, nor on the longer section up what I've called Owlwood Hill. Then if I might turn to viewpoint 16 on Runklaw and the Hardens Hill Road. The council stated the viewpoints is sensitive but didn't agree with the medium sensitivity that I have set out. Didn't disagree with that in the planning report either. Ms Platt suggests a high medium in her hearing statement for the council. For the avoidance of doubt, I don't use intermediate levels and I round up to a higher level rather than saying borderlines of medium high or medium low or something like that. So that is set out in my methodology.
And so in our instance, so for instance, if you were concluding a medium sensitivity, then I could assume you've either found it to be medium or slightly less than medium, but enough to settle on medium as being a conclusion.
That's correct. If I had a more borderline of medium high, I would push it up to a high, but wouldn't use that phrase. Yeah.
No, I understand what you're saying. Okay.
So this view is looking out from a hillside where the top of the hill's got more open views to existing wind farms to the north and southwest. But the top of the hill has limited visibility of the Doington Laws themselves. They only become visible as you round the hill, approximately 250 metres uphill from the viewpoint. So there are 180 degrees, including existing wind farms. Black Hill ahead, but also Crystal Rig Group to the north. They're probably the Aikengall turbines again. So the proposed development will be 6.5 kilometres away, 6.6 kilometres away, and the landscape between again is visible. So there is a sense of a distance between the viewpoint and the wind farm. Ground level infrastructure and solar panels will not be visible. The proposed turbines will be located between the Derrington Great Law and Hardens Hill as shown on the figures. They will not be behind or in front of they'll not be behind or in front of Dirrington Great Law, so the profile of the hill will not be interrupted. Might be worth going to the visualising themselves at this point.
Just give me a second. I'll get that. Do you want all of the viewpoint 16 ones, or is there one particular one that you'd like us to look at?
I'm happy to go to the final figure, just the photo montage.
The montage, just a moment there. Okay, I've got that.
So I've just been describing that they're not going to be behind or in front of the Dirrington Great Law, and are not going to interrupt the profile of that hill. They will be larger in this view than the Black Hill turbines, just looking at it as a plain view, and again, probably rotate a bit slower. Black Hill is about 4.7 kilometres away at this point. So they may alter the perception of the hill for some viewers who might use them as scale indicators, but again, they don't interrupt the profile of the hill itself. It's my professional judgment that the effect on the view will be significant, but in the presence of Black Hill and other wind farms in the panorama that you've experienced in approaching that viewpoint and being there, turbines won't be a new feature that's unfamiliar to the view, and although they'll be in the direction of the Dirrington laws, will not affect the experience of the panorama as a whole to the extent of a major effect. So therefore I judge it will be moderate, significant.
And I think Ms Platt earlier was making a point about vertical competition. I think it was in this particular viewpoint between the proposed turbines and, I think in particular, Dirrington Great Law. Do you have thoughts on that same matter?
I have set out in my assessment that the tips of the turbines will appear to be about the same height in the view as the top of Dirrington Law. I would point out that in a lot of lights, it's actually the turbine towers that are more visible than the turbine blades. So it may be the blades that, the tower heights that are more obvious in the view.
So in this particular example, the visualization we're looking at, just looking at the positioning of the blades on the turbines, and I think the far left turbine is possibly the one that appears most vertical. Possibly one of the ones to the right that's behind. So does the one on the far left, is that the one that's of similar height in your opinion to the hill? I'm asking everyone to make a judgment. So
that's correct. It may be easier to turn to the wire line that precedes that page.
right, let's do that.
That's page C.
Okay, I've got that. All right, yes. So I can see on that all the turbine blades are, shall we say, at their tallest. If
Yes.
that's right. So on you go then.
So yeah, this is just to take you to this viewpoint. It shows the turbines going up. Sorry. As we've just said, the one blade is vertical, and it's turbine 5 that is going to appear to be highest in that view.
So I diverted you from something that you were in the middle of talking of when I asked you that question. So yeah, I'm happy for you to return to where you were, or what have you.
I think I had more or less finished.
On that, or on that particular bit, or on all the things that you wanted to say?
On that particular bit, for the Hardens Hill Road, I've also set out that that's the road down from viewpoint 16, that section of it, even though Hardens Hill itself is much further south. I have set out that there would be significant moderate effects on that road, on the descent past viewpoint 16 on Runclaw, down towards Longford Acres, but not all the way down to the village. And I've also identified significant effects along that route from a section south of Longford Acres, past and through the site. And
I'm sorry, were those also moderate, or were those major significant? Sorry, it's something I should know, but
that southern section is major, I think. Just going to double check.
Would that be due to the closer proximity to the proposal?
That's correct.
Yeah.
And that's confirmed. I've got a table summarising the effects. Better still, in Technical Appendix 6.3.
Document 1.170, Technical Appendix 6.3, internal page 40.
Which is a table that summarises the effects. It is also set out in the text earlier in that appendix, but it says significant major from Langton Edge, which is within the site, northwards to Kippet-Law Burn, which is south of Longford Acres, and that corresponds with the pink line on map 5.
Yes, I see that, and I think you previously indicated that you agreed with that conclusion, and that I think.
I believe Ms Platt has taken that extent from the LVAA. I think that was everything on that question.
Okay. So before we move on to Part E, I'll allow the other parties just to respond to that, and then I'll let you pick up any issues that they raised before we move on. So you've heard the response and also the applicant's position. Did you need to say anything more then in response to that, or add anything?
I just had a couple of minor comments to respond back. With regard to viewpoint 15, which we keep returning to, I just wanted to make it clear it's perhaps more for people watching on the webcast that when we ran through the wireframes, a number of the wind farms which are illustrated there are proposed and in planning, and it can seem on the wirelines for viewpoint 15 that the current wind farm situation is greater if you don't have an understanding of the colouring of those turbines in there. So that was just a clarification point for viewpoint 15. I think also I wanted to pick up the discussion about not affecting the whole panorama. When I was making my judgments and assessments for both viewpoint 15 and viewpoint 16, I was mindful of the methodology outlined by the applicant, which is in one of the technical appendices. We don't necessarily need to jump to it, but some of the determinations for higher levels of magnitude are informed by the degree of contrast or integration of changes within the landscape scene, and I take that to mean interaction with prominent features and the interaction with the main focus of the view as well. So it's not just the judgment of whether the proposals seem more distant or smaller, or whether they occupy a position which interacts with the full 360-degree panorama. So within both of those judgments, part of my determination really focused on the interaction with the key views towards the Dirringtons and their prominence within the view. And that was all my comments.
I'll let you come back on those points for anything that you want to address before we move on to E, and then once we've dealt with E, I'll let you close and what have you.
Yes, I'm happy to respond. Indeed, taking you through the wirelines, I did not mean to refer to all of the cumulative wind farms. It was only existing wind farms, which are coloured in dark blue, I think. So yes, it was only in reference to the existing wind farms in the panorama. And just to be clear, I have not included proposed wind farms in the judgment that effect in this scenario.
So as you mentioned, there's a key, and I can differentiate between those.
There is a key,
as
yes.
Yeah.
Yeah. And in reference to the second point, yes, I have considered the position of the wind farm and the portion of the view and the relationship with the Dirrington laws as features that are recognisable in the view as part of my assessment, yes.
So does that mean the difference is essentially how each of you separately perceives that and your conclusion? You appear to be saying to me that you've both taken into account the same things, so as different professionals you've reached different professional positions on the effects.
I believe it is, yes. No, thank you.
I implied something about what you might think just there, so I should at least give you an opportunity to say whether that's the case.
And that will be the case.
Any more before we move on to part E?
No, thank you.
So let's, having spent some time considering those matters, my question in point E was that parties will be asked to say what practical differences they think will be consequent from their own position versus that of the opposing view. So I'll invite the Council and DLH SOS to go first on that, and then we'll hear from the applicant.
Yes, my interpretation of the consequences of the opposing view would be quite a large expansion of highly adverse, so the major levels of effects, which expands to 9.5 kilometres, and my understanding would be that really represents a lack of containment and a lack of localisation of effects when they're expanding to that distance at that degree of impact. I also conclude that the broader spread of high levels is trending towards the north and the west, and that's creating the impacts on the Lammermuir Hills SLA, which we discussed earlier, where those visual effects interact with the key qualities and characteristics.
Did you want to say more?
No, I've got nothing further to add.
Okay.
Thank you. I believe that we are not in disagreement with the extent of significant effects.
Is that the 9.5 kilometre point that was made?
Yes, I believe so, yes. And I think the extent and localised effects is a matter for Mr. Bell, the planning witness for the applicant, I believe.
Not the extent, but the
Sorry, yes, the implications thereof.
it's not so much the extent, that's for...
No, indeed, yes, apologies.
For the implications in policy terms of David Bell.
I think I understand what you were saying. Yes, the policy consequence of what you were saying is for... Yeah, okay, I understand.
The other point I wanted to make is that GLVIA 3, the methodology for landscape and visual assessment, I don't need to take you to it in a moment, doesn't require a landscape and visual impact assessment distinguish between significant moderate and significant major effects. It reflects EIA regulations which require you to assess whether, identify whether effects are significant or not. And GLVAA 3 adds that levels of, within effects, levels of effect are optional. That's on page 40 of GLVAA 3, if you wish to refer to it.
40.
Page 40, yes, page 40.
Document 8.1.
Paragraph 3.3. If that helps. 3.33 indeed. So yes, some landscape consultants don't identify levels of effect within significance and basically treat significance as either black or white. And again, in my methodology, I have said that moderate and major are significant, but not moderate / major. I haven't used those sort of intermediate levels. So once identified as significant, my understanding is considered in the planning balance.
Could I just add to that from a policy perspective that policy 11E2 of MPF4 just uses the word significant. It doesn't differentiate between levels of significance. And the same when it comes to policy 4D on the SLA, it doesn't deal in levels of significance. So looking at, well, what difference does it make, which is the question you asked. And ultimately in the planning balance, you may or may not choose to give greater weight to major effects as opposed to moderate effects. That would be, I think, where it flows out of the tap. It doesn't flow out in the application of policy.
Did you want to say any more?
Nothing further to add.
Just
Yes, I'll let you come back.
Just important to note that paragraph 3.33 in the GLVIA does specifically say it depends on the nature of the project, the character of the project it's talking about. So it's a slightly qualified exclusion of levels of significance. As ever with this document, there's something for everybody, but it's not exclusionary in the sense that perhaps you portrayed it. It says it depends on the project. So that presumably means very large, very small.
So does that mean that it allows you to do what's been done in the case by both of our professionals? It doesn't prevent that from being the case, i.e. it doesn't prevent you from saying major, moderate, or major significant or moderate significant. It allows you to do that. It doesn't. Is that what it's saying?
Yes, it does, depending on size and location.
I'll let you respond.
It doesn't indeed allow you, it doesn't say that you have to though.
Okay. Any more?
I just wanted to just to say that in case of doubt, the extent of the visual effects is 10.7 kilometres. That might have got a bit confused when we talked about the extent of major effects to 9.5 kilometres. The overall extent of significant adverse visual effects is 10.7 at Hume Castle, which is viewpoint 20.
So you were saying 9.5 was the major and 10.7 was anything that was significant, whether it was moderate or major?
Yes, that's correct.
Are you in agreement with that?
I agree with the 10.7 kilometres. That's viewpoint 20 at Hume Castle.
Is there any more on Part E before I invite the applicant to close? No? Okay. Want to close? No? Nothing more to say? Right, okay, let's move on then to matter 3. Where are we time-wise? Yeah, we're fine. What I think I'll do is probably take soundings from everyone around 3 o'clock, see where we are. We might look to take a breather around then before we get into matter 4. So this is cumulative matters, and I've asked a question here. Would the proposal change the area into a wind farm landscape or otherwise fundamentally alter the pattern and distribution of wind energy developments in the area? So I'll invite Ms Platt to go first.
So the Scottish Borders Council policy, Renewable Energy SPG, looks towards the Ironside Para 2016 Wind Energy Landscape Capacity Study. And within that study, the regional area of the Lammermuir and Moorfoot Hills is described as having extensive areas of landscape with wind turbines across the Lammermuirs and extending both east into the coastal zone and west into the plateau grassland. The largest clusters at Crystal Rig, Aikengall and Dunlaw, Toddleburn are in effect wind turbine landscapes. And you can find that within the capacity study. The area of LCA 102, so this is the eastern portion which contains one turbine, is classified as an upland fringe, which is upland fringe with occasional turbines, and that's due to the siting of Black Hill to the north, 3 medium-sized turbines to the east and small-scale turbines to the north and south. The portion of the site within Landscape Character Area 105, which is to the west and contains 5 of the turbines and a large proportion of the solar photovoltaic panels, is classified as landscape. Sorry, this is my notes are getting confused at this point. This is classified as no wind farm development, so upland fringe with no wind turbines. In my hearing statement, I think I mentioned towards the easternmost portions that changes, but in fact, within the capacity study, it's classified as upland fringe with no wind turbines. In looking at LCA 102, which is the one I referred to first, which is the area with one wind turbine proposed, which is currently the upland fringe with occasional turbines. My judgment is that due to the one turbine being sited and views the development with up to major levels from various points within the character area, which is along the A6105, includes viewpoints 2, 3, viewpoint 1 and the Southern Upland Way to the east of Long Formacus, I judge that will change to a landscape with wind turbines for the majority of the LCA area. And when passing along the Hardens Hill Road section, which moves between the proposed Lees Hill development and the existing Black Hill development, that will turn into a landscape with wind turbines, a wind turbine landscape. So that would in
Sorry,
effect...
can I just jump in a second? You used the word landscape with wind turbines and then you said wind turbine landscape. I just wanted to... And I think about 2 minutes ago you used the, with regard to, was it LCA 102? You said, I think, landscape with wind turbines. I just wanted to make sure that you were telling me what you wanted to tell me was the correct thing for that. So you might have been doing, it was just when you used both terms in the most recent sentence.
No, apologies for that. So for LCA 102, the existing situation is with occasional turbines. My judgment is that this will change to character-wide area of landscape with wind turbines, but with pockets of wind turbine landscape when passing along Hardens Hill Road between the existing Black Hill and the proposed Lees Hill.
Just give me a second, I'm catching up with you. And did I understand you correctly that last bit where what you said, I think a pocket of wind turbine landscape, was that on the part of Hardens Hill Road? Is it around viewpoint 1 where presumably you would see both Black Hill and the proposal on either side of the road. Is that what you're referring to?
Yes, that's correct. So it will be moving past viewpoint 1 and to contain something feeling is passing between a landscape which becomes more dominated, which is why I determined a wind turbine landscape at that point. For LCA 105, which is the portion of the landscape which contains the majority of the development, the current situation will be upland fringe with no wind turbines, and there's no wind farm development within that LCA. And obviously remembering that this landscape character area is a very distinct area, and it's the only occurrence of this landscape area in the country. The siting of 5 out of 6 of the turbines in that area, and the combination of the open and clear views from all parts of the character area, the dominance of the turbines against the scale of the landscape, and the redefining of the features of the Dirrington laws, the juxtaposition and the issues of scale and interaction with the features which we've discussed. My judgment is that this will change to a wind turbine landscape throughout the landscape character area. The impacts, this judgment's based on the cumulative impacts with Black Hill, the scale of the proposed turbines against the host landscape. Those are the compounding factors. And I felt that would be in accordance with descriptions within table 2.2 of the capacity study. This describes a landscape type or area in which wind farms or wind turbines are extensive, frequent and nearly always visible. They become the dominant defining characteristic of the landscape. That's within table 2.2 of this Borders Council capacity study. And it also goes on to describe visual receptors would experience views of wind farms and wind turbines as foreground, midground and background features to the extent that they are seen as the most dominant aspect of landscape character. Few areas would be free of views of wind turbines, although the principal groupings would appear separated. This was the judgment that when you are moving within the landscape, so not only along the roads but within the rights of way and potentially accessing Dirrington Greater Law or Dirrington Little Law, that the experience will be that the wind turbines will be quite dominant within the views and would redefine the landscape to that extent. In terms of the wider patterning, I know that we will move on to this within cumulative, but the...
Sorry, we're in cumulative now.
Are we? Sorry, we are. My apologies. It's been a long day already. So the wider patterning, which is obviously key to the cumulative section. So the sightings of the proposals within this transitional landscape, the upland fringe, is what will be marking the change to the current placement of larger scale development within the larger. So making a change from the current placement of larger scale development within the larger interior moorland. The transitional landscape has a more limited capacity and limited scale, sitting towards the periphery. The proposed development is drawing wind farm influence further towards the treed lowlands, and it also represents a marked increase in size from the existing Black Hill wind farm. And from viewpoints within the higher ground and hillsides of the Lammermuir Hills, and this would be viewpoints 15, 14 and 16. My judgment is that the development appears to connect visually to the lower lying landscape, and I think this is echoed in the applicant reports, and it steps away from the upland moorland landscape. And from within the Tweed lowlands, so from the south, the scale draws development closer to the viewer, alters the perceived distant placement of wind energy development within the moorland landscape, usually perceived as distant and attached to the uplands. And this will be from viewpoint 20 at Hume Castle, from 9 at Westrother and 19 at Hounslow. This is further accentuated in the in-planning scenario when set against Dunside, which is sited towards the southern edge of the Lammermuir Hills, and with Ditcher Law, Glen Burnie and Newlands wind farm proposals.
that's all for now.
A few things to respond to there, so I welcome you setting out both your position and responding to that.
Perhaps the first thing we need to do is to go back to the definition of a wind farm landscape, which is part of your question. Again, the capacity study that Ms Platt has referred to, that's document 1242, capacity study, that's on page 8, but it's electronic page 16 if that's easier. So there's a table there that has levels.
Would you like me to bring it up?
Yes, it might be helpful.
Right, you might have to give me a second. What did we say, 12.42?
Yeah. Electronic page 16.
It'll just take me a second to locate it, so hopefully that'll give others time to do the same. I'm sorry, I'm seeing the document, but it's not opening for me for reasons best. Oh, hang on, no, we're there. I'll probably get it about 7 times now. Right, you said electronic page 16.
Yep.
Okay, so I'm looking at a table entitled Table 2.2 Description of Levels of Cumulative Wind Turbine Development. Is that correct?
Yes, that's correct.
Okay.
Yes. Just to say this table has a series of definitions of descriptors for a landscape with varying levels of wind energy development. Doesn't actually include wind farm landscape, doesn't actually include landscape with wind farms, but wind turbines, wind farms. I've also used the term with wind farm clusters. So there's different levels of describing. Those descriptors have been coined by practitioners quite a long time ago and have sort of been adopted by many different studies and has got into this, but they don't have a policy or guidance origin. It's just been a series of terms that have been used to describe the level of wind energy development. So I could go through them, but I think the definition is there, and it's quite useful. So just to start off with, a wind farm landscape, if I do go to that point, I would say that a wind farm landscape is something that's completely dominated by wind energy development. You're perhaps within a cluster, so within Crystal Rig Group or within the Dunlaw Group, or possibly within a wind farm like Falago Rig, where you're surrounded by turbines in all directions and you know, multiples of them. And a landscape with wind farms is one in which wind farms are frequently experienced. Landscape with occasional wind farms, they are present but less frequent. And when you can go down to obviously a landscape with occasional turbines or no wind farms at all. So I think it's also important to define the geographical area one is talking about. So the whole of the Crystal Rig Group, for example, extends to over 9 kilometres from east to west. taking small areas, Falago Rig wind farm site is approximately 3 kilometres across. And as I said, it could be described as a wind farm landscape within that. But the description of wind farm landscape falls away quite quickly as you leave the edge of the wind farm site.
So presumably with the two examples you've got, do you mean if I was standing in the middle of them and therefore I was surrounded by
That's correct.
those developments,
Yes.
I would experience a wind farm landscape?
Yes, you would.
But as soon as I left one end or other of them, then that experience would alter from being dominated by wind turbines to being less so in some way.
Yes, you're not within we're not within a wind farm, you're in a landscape with wind farms adjacent to you, near you, around you, yes, but not in the wind farm landscape. So you can go into smaller scale areas, but you can also expand into bigger areas. But again, it's important to define the area you're talking about. And so the Lammermuir Hills across the northwestern part of the study area can be described as a landscape with wind farms, or wind farm clusters indeed. This can certainly be seen by a number of elevated viewpoints, some of which I think Ms. Platt has taken us to. For example, viewpoint 15 that I was talking about before. My cumulative assessment sets out the southern uplands can be described with occasional wind. So I've set out in the EIA and in the updated cumulative assessment that the southern fringe of the southern uplands, southern fringe of the Lammermuir Hills part of the southern uplands, is a landscape with occasional wind farms, and that would be extended a little further south by the proposed development. I think that descriptor of landscape with occasional wind farms holds as one zooms in towards the proposed development site. Just turning to taking the units of the landscape character types, LCT 102 described as occasional with occasional turbines, I think that was right. Black law is present within that landscape character type, and I have judged that that doesn't change from occasional turbines. There is only one more turbine going to be in that landscape character type. There's going to be one more turbine within that. And LCT 105, which includes the Dirrington laws and would contain 5 of the turbines. That I would not find as a wind turbine landscape. If we go back to the definition in the capacity study, it's a wind turbine landscape if they become visible everywhere and clearly defined by those by wind turbines. I would say it's a landscape with wind farms. Sorry, it's a landscape with a wind farm in it. I don't think you can put the plural on that, and I don't think it's a wind farm landscape. And again, one might use a landscape with wind turbines, but not a wind turbine landscape. Sorry, I got myself in a bit of a tangle there. But I think we're...
No, I think you talked me through. I understood the point you were making, I think.
Yep. With respect to the pattern and distribution, There is a pattern of wind farms in the study area as one on high ground, on hills and on the plateaus. And this is illustrated in the cumulative maps that are in the updated cumulative assessment.
Would you like me to have those?
Yes, that might be helpful.
Which one would you like?
Figure 6.9 is document 11-233.
Figure 6.9, just a moment. Figure 6.9, cumulative baseline within approximately 25 kilometres, and it appears to have the proposal and various colourings of dots which represent wind farms, and apparently no other indications of other criteria.
That's the correct figure, thank you. I suppose just taking the black dots to start with cumulative is in the sense of increased development rather than actually cumulative as in potential future scenarios. There is a pattern, the pattern of wind farms in the study area is one on high ground in the hills and plateaus. The LVIA does state that the proposed development will be on lower slopes with hills to the north of it. There are some viewpoints where it can be seen in the Lammermuir Hills, in front of the Lammermuir Hills, for example, viewpoint 20 in Hume Castle, to which Ms Platt referred just earlier. But it would be seen as part of the uplands from an awful lot of other viewpoints. And I think that it is part of the experience in the round that one has going round the area and seeing it as part of the upland. It's not part of the lowland, it is on the fringe rather than down in the lowlands. But it is below some of those hills. Although it's in a transitional landscape between two landscape character types, that's not unique in the borders either. The examples of wind farms on transitional sites include Aikengall, which I think has a few turbines in lowlands upland fringe. I might refer at this point to a slightly different map. 6.5a.
Uh, 6.5a, landscape character types with cumulative wind farms. Is that the correct one?
That's correct. It's document 1229.
Okay.
My example of Aikengall is not actually shown on this map. It's just off the northern edge of it. But another example I would like to point out is the Drone Hill and Penmanshiel group, so the northern end of that, the extent of the map, a little bit further to the right. That group actually extends into three, including, if you can find it on the key, coastal farmland, coastal moorland and pastoral upland fringe valley, as defined by NatureScot in the landscape character types.
So just to be clear on the one that you're talking about, if you follow, there's a I think is that the A1 that is running from the top across the top right hand corner, and can you see Grant's house just at a point where there's a junction in that road, and there's a series of wind turbines to the north of that? Is that the ones that you're talking about?
That's correct. It's the black dots north of Grant's house.
Okay, I'll point to those on my map. I would understand that I've been directed
If I
to
could
these.
just inject a little local knowledge, that's not the one she's talking about. That's Penman Shield and Quickswood and other ones. The Drone Hill one is further to the north, near the coast.
I'm sorry, what did you ask me to tell me I was referring to?
Sorry, can you put your mic on?
I shouldn't interrupt. I was just trying to correct what may be a mistake. The ones at Grant's house are not the Drone Hill. The reporter put a question to you about being next to Grant's house.
No, I was asking whether what I'd been referred to was those particular ones, and I understand initially you had said forgive me, the Dun something.
Penman Shield.
You'd initially referred me to some that you said were off the map, and then you referred me to another one which was on the map, which was in 3 LCTs, and I was just clarifying whether the one that you were asking me to look at that's in 3 LCTs was the one to the north of Grant's house.
I'm referring to a group which includes, if you refer again to figure 6.9, it includes Drone Hill, Moorhouse, Penman Shield and Howe Park. I abbreviated that to Drone Hill Penman Shield group. So I apologise, yes.
Sorry, my intervention was well-meaning, but doesn't serve to confuse. Apologise.
That's fine.
Let's continue then.
By comparison with the figure 6.9 group and the dots on figure 6.5a, I believe that we're talking about the right group. And yes, my point was that it spans several different landscape character types, 3 different landscape character types. Another wind farm I might refer to is Quickswood. Which is labelled on figure 6.9. So it's further southwest, of that group that we've just been looking at.
And does that appear on figure 6.5a, clustering around the number 100, which I think marks a contour line?
That's the correct group, yes. In the pic. If you go on site round there, it's seen from the northeast as being in front of the hills and very much on enclosed farmland. Going back to the point of the proposed development being on in front of the hills and in landscape character types that are transitional from moorland to enclosed farmland. So there is part of the established pattern of wind farms in front of the hills and on enclosed farmland. So I don't find that the pattern of distribution of wind farms will be disrupted by the proposed development. I think that's all my points on that question at the moment.
Before we leave that point, when Kelly Platt was giving evidence, there's no criticism, she was giving evidence of what government loves calling at pace. And I just need clarification of something, if I may. In relation to LCT 102 and LCT 105, do you mind just rehearsing again what you said about the wind farm landscape point, how you were describing those units with and without Lease Hill? It's just so I have a note of your evidence.
Yeah, I'm happy. I think that would probably be helpful just to clarify matters to help us understand where things are. So yeah, if you want to do that, that'd be really good.
So LCA 102 I described as without Lees Hill currently, is upland fringe with occasional turbines. And my judgment was that this would change to a landscape with wind turbines for the majority and a portion of wind turbine landscape.
And am I right, the portion with wind farm landscape, that was the bit along Hardens Hill Road, did I understand that?
Yes, that's right, and it's...
Which I think probably marks the boundary between those two LCTs,
yeah,
isn't it?
it's borderline LCA 105, LCA 102 as you pass along Hardens Hill Road. And then for LCA 105, the current context is upland fringe with no wind turbines. And I judged that to change to a wind turbine landscape.
The whole of the area.
For the whole of the area.
And is that judgment due to the size of the... I think you mentioned, I think when you were speaking before, that this was the only landscape character type, sorry, the only example of that particular landscape character type in a particular area, and you can tell me what the particular area was. And was it that factor in particular, or were there other terrain, topographical features that persuaded you of that?
Yes, LCA 105 is the only occurrence of that landscape character type. Usually you'll find that there are other occurrences in the area, but this is quite a unique and distinct character type.
And when you say the area, are we talking the United Kingdom, are we talking Scotland, are we talking southeast Scotland?
Scotland-wide.
So this is the only example of that in the whole of Scotland?
That's my understanding. And it's referred to as a sensitive area. The Greenlaw Common area is a distinct landscape character type. The determination and my judgments in terms of the wind turbine landscape were based, yes, on the scale of the turbines. I appreciate there is a discussion regarding the wind turbine landscape may be a landscape where you're passing through a wind farm, but I think that the descriptor, for me, my reading of it is that actually it's about the dominance over the characteristics, the frequency of the views. And I read before the descriptors, so where wind turbines are extensive, frequent and nearly always visible, becoming a defining characteristic. I felt that the scale of the turbines against that landscape, it's a very open, flat landscape. The turbines stand out prominently and are very much a defining characteristic.
Okay, was there any more on that? I'll have an applicant come back in a minute, but you're happy with that? Okay, I'll let you respond.
Thank you. I think possibly just taking them in turn. The first point is landscape character type 102 does exist elsewhere in the borders, in Dumfries and Galloway, elsewhere in the country. We are talking about this occurrence of the landscape character type rather than the landscape character type as a whole.
You referenced the LCT 102? Sorry, did I misunderstand? Was it LCT 105? Was what I understood Ms. Platt to be saying was the only example in Scotland. Have I misunderstood things?
No, I'm currently talking about 102.
Sorry, yes, I referred to 105.
105.
Okay, I'll let Ms. Platt clarify what she was saying, then I'll let you come back. So do you want to just repeat that? Had I understood properly what you were saying?
Yes, so I was referring to LCA 105 as the distinctive character area.
So on map figure 6.5a, this one, LCT 105 is the orange one that contains the Durrington laws, and you're saying that is the only example of that in Scotland, to your knowledge?
That's my understanding, yes.
Okay. Notwithstanding that you wanted to take me to 102, and you're welcome to do that, I just wanted to make sure I was understanding where you were coming from.
I agree that 105 is the only occurrence of 105. I was answering the question in the order in which Ms. Platt
That's fair
answered
enough.
it,
My
and therefore-
apologies, in which case I heard something immediately before, and no, it's not your fault, it's mine. Right, you tell me the things that you need to tell me
If
in
I
the
may
order
talk
you'd
about
like to tell me.
102. So perhaps I've made my point about 102. Okay, moving on to 105. Yes. So it's currently you said it's currently a landscape with no turbines, and it will change into a wind turbine landscape as a whole. I disagree with this because the turbines will not be over the whole. They will be peripheral to the landscape character type. They're very much in the corner. There's 5 of them. They won't be surrounding the Durrington laws. They won't be south of the road. They won't be in the whole area of the landscape character type. I think what has been relevant here as part of your agenda question was whether it's a wind farm landscape, which I think is a different kettle of fish. So I think that's the main point I wanted to make on that.
The relevance of it being unique.
So yes. I think your question C was also, sorry, 3 was also about cumulative. So in scenarios that are the future scenarios, the map 6.5a shows that there are future wind farms proposed in various parts of the different landscape character types as well across the study area, such that the pattern of wind farms is consistent into the future, taking the cumulative scenarios that I've addressed.
So did I understand properly? So if I look at 6.5a, and I see in the key that we've got existing, we've got construction, application, scoping. Did I understand you properly? You were saying that even when I consider that scenario, that future scenario along with the proposal, the cumulative pattern that you described to me earlier is maintained. Is that what you were saying?
I am, yes. Yep. And again, going back to the landscape character type 105, the fact that it is unique, it's the only occurrence in this this area, has a bearing on its value, but doesn't have a bearing on how it's described. Particularly, you would just describe it a landscape character area with respect to the amount of turbines in it, wherever you would take it.
Okay, were there any points you wanted to make?
Not at present.
A couple of issues that I appreciate you might want to come back on. So, were there any?
Yes, just a couple. Just with regard to, we were taken to some other wind farms in the area in terms of patterning, and I just wanted to point out that they were of a much lesser scale than the proposed Lees Hill. I've not checked them all, and I don't know all of the heights off the top of my head, but I think we're looking at up to 120. 100, but as I say, I don't know that for sure. So the proposals of up to 200 metre high turbines represents a different scale and is not really comparable to a smaller scale of wind farm in a transitional landscape. This is a very large turbine sitting against a transitional landscape. So I wouldn't agree that that's necessarily a representative comparison. I would be interested in taking you to one of the viewpoints as well, just to illustrate.
Which one would you like to go to?
To viewpoint 13, which is Durrington Great Law, and find that at 001.251. figure is 6.24.
What did you say? Sorry, 001
001.251,
251. And that's Durrington Great Law.
Durrington Great Law.
Right, let's give everyone a second to find that.
Well, for you, you don't have to turn the pages.
Do you want me to get all of them, or is there one particular one?
I think all of them
Okay, let's have
would
all
be
of them.
helpful.
Okay, I think everybody's got those in front of them. So do you want to take us through the things that you want to show us?
Yeah, so the first image on there is obviously the baseline photograph, and you're looking to the southeast, I think, over the moorland, over the SLA area.
I'm sorry, is this A?
This is A, yes.
Hold on. So I thought I'd had foolproof labelling, and I was clearly wrong. Right, I've got it now. There we go.
So you can see the moorland, and then the change, the transition, as the moor changes to the improved grassland, the brighter green, and this is just highlighting the transitional landscape. Below that photograph is the wireline. You can see the positioning of the turbines at that moment of change within the landscape. And then if we just move downwards, downwards is on my screen, but move through the figures to C, that gives the context for some of the wider patterning.
B, was it?
C.
C.
So the
And I'm sorry, and C is looking in a different direction to the previous one.
yeah, sorry. So this is moving around the panorama, and this is looking in the northwest into the uplands, and the existing turbines are in the dark blue, as we discussed earlier. The orange ones are the proposed future ones. So both within the existing cumulative baseline and the future proposed baseline, the majority of the wind farms there will be seen in connection to the upland landscape, and this includes proposals which are shifting towards the larger scale patterning of the wind farms. The next couple of images, so I presume that would be D, and so D is looking towards Black Hill, which is in the north to a greater extent, although it is moving into the transition. You can see some of the field patternings, woodland cloughs, but it's, in my opinion, it relates to the landscape scale. And then if we move towards the last visualisation, which is F, I believe, that's got the photo montage with the proposals. And in comparison, these appear on the flat ground. You can see the connection of the bases towards the more patterned landscape. They're seen against the populated landscape resource of the lowlands, and they're very large in comparison to those landscape features of the linear woodland cloughs, the field boundaries, and the settled resource. And that breaks, in my opinion, the current context of associated to larger scale landscapes and the uplands. I think it also helps to illustrate what I was saying earlier about the wind turbine landscape, that the nature of this landscape area, because it's flat, open, the views extend throughout the landscape area, that the turbines at such a scale will become a very dominant and defining feature and will draw the eye across what is in effect quite open, and I don't want to say featureless because it sounds slightly diminishing of the landscape, but the moorland context is that your eye will travel around the landscape without specific features apart from the Durrington laws, and that these will become part of the dominant visual focal point of that landscape. That's all for now.
Okay, thank you for that. I'll invite the applicant to come back and respond then. You're welcome to take us through bits of this one again if you have a different opinion. That's what you'd like to do.
Sorry, I didn't hear your question just there.
Yeah, I'm happy for you to respond to the points that have just been made. And if you want to, if you want to stay with these visualisations and use them, happy to do that. Or if you want to refer to any others, then please do so.
Thank you. Yes, I suppose just to turn back a couple of pages in terms of the cumulative wire lines and the baseline photographs.
Is this still for viewpoint 13?
It is viewpoint 13, yes.
Okay, that's good because I've got that. I don't have to find another one. Okay.
It was just to make the point that the Durrington Great Law is in the middle of this landscape character type, and from the top of Durrington Law, the parts of the landscape character type that are in different directions of view will not become wind turbine landscapes, because the turbines of a proposed development will not be in those views and in the slopes running down from the Durrington Great Law within that landscape character type, and also south of the road as part of that landscape character type, which goes back to my me saying that it's not going to be a wind turbine landscape. And also the looking in terms of cumulative proposals, the proposals around the study area are increasing in size up to 200 metres, and I think Crystal Rig 4 is about 200 metres as well. So there is a trend in that direction as well. It's a smaller number of turbines rather than the multiple turbines in some of these big groups, but there's also a trend for small developments as well, in terms of small numbers of turbines as well. Thank you, I think that's everything.
Okay. Any more to say?
No, I don't have any. Further comments?
I think that was a no further comments, was it? Yeah, okay. I suspect that is probably our mic system telling us that it's almost time for us to have a breather. But before we do that, we've come to the end of matter 3. I'll just offer the applicant any opportunity to close if you'd like to. No, all said and done. Right, okay. So I think we'll have a breather just now, and before we do that, that'll then bring us on to matter 4. People have said they were happy to stay and to try and get this one through by the end of the day. What kind of optimism is there amongst parties that we can get that? I mean, we're relatively relaxed about staying. People might need to be away.
I am not really able to stay much beyond 4 o'clock. However, it may be that the council it does not form part of the council case, so my absence may not cause an issue, subject to other parties' views.
Mr. Campbell?
I'm just looking to see how many questions you have.
Mr. Trinnig?
I don't think. Sorry, apologies.
We do get to a point of diminishing returns in the late afternoon, but
I think with 10 minutes, I mean I can be back in the room ready, but
I just want to say that we're prepared to stay if it suits everybody else.
Mr. Trunick.
I think the problem with this topic is that it does go up to J and there are a lot of overlapping issues. We could certainly deal with 4A through to C. Once we get on to matter 4D, there's some blurring between 4D and 4J. I think if we get to the end of 4C today, that'll be good. And I might be tempted to ask you to start at 9:30 tomorrow morning and finish it off tomorrow morning. We've still got plenty of time. Policy and conditions are not going to take very long.
Other parties' views?
You have very full witness statements in respect of this topic, or this section of the thing in relation to matters D onwards. You don't propose to lead evidence or encourage evidence in front of you which repeats those witness statements. So I'm going to discourage intervention by Mr. Whitfield unless something comes up which only he can answer. And he knows that because his statements are already before you and there's absolutely no point repeating them, except perhaps for emphasis, but certainly not ad longam. So I remain optimistic.
Okay, so, well, look, I think what I'm hearing is we'll maybe have a go at getting to part C and see where we end up. If we need to come back tomorrow and do those bits, appreciate that you need to be away by 4. In your opinion, I suspect the council for the first one, perhaps we need to, but it's up to you to tell me if you think it's more or less important that someone is here for the other bits and whether you feel prejudiced by that.
I mean, it is a matter of agreement that this does not principally form part of the council case. So whilst I believe Mr. Wise will stay, I don't think it's prejudicial that I would be absent for the majority of this if it were to continue beyond 4 p.m. this afternoon.
Right, okay, well, I think we'll have a quick breather then by the time we've finished this. Where's my phone? Where are we? Getting buried under paper. Right, that says 15:18 on my phone. Can we come back at 1:30 then, please? And is everyone getting a bit warm? Because I'm the only one sitting with a jacket on, so I think I might have to dispense with that. But the doors will be briefly open. So, yeah, let's have a quick break, then we'll come back and we'll see how far through we can get. Okay, welcome back everybody. That's just gone 3:30. I should have said much earlier in the day. Just because I was wearing a jacket doesn't mean everybody else has to. So please, body temperature is more important. So just get yourself to a state where you're comfortable. We've turned the radiators down a little bit, so it's always slightly difficult to control these things. Right, so just before the break we agreed that we're going to make our way at least to point C of matter 4, so we'll see where we get to. Matter 4, Residential Visual Amenity Assessment, RVAA. So the reporter notes that the Council did not originally object on the basis of Residential Visual Amenity Assessment. The Statement of Agreed Matters, SOAM, between the applicant and Council also confirms the Council's satisfaction with the EIA method and wirelines, etc. However, the Council appears to cover Residential Visual Amenity Assessment in its hearing statement. And I would just welcome a brief explanation of this matter from the Council. I think you started to touch on this just before we broke, but you're very welcome to just take me through that.
Yes, so can you hear me? No? The Council don't consider that residential visual amenity is affected to such levels to become a matter for objection, but it is included within the hearing statement due to the very high levels of effects determined and the potential which was originally identified by the Council Landscape Architect for potential overbearing effects. The impacts on residential visual amenity form a further element of the range of impacts which contribute to the wider effects of the proposals, but they've not been taken forward in isolation. So on that basis, it's included as part of the wider level of high impacts, but it's certainly not considered that the threshold has been crossed by the Council and it's not taken forward as a matter of objection.
Okay, thank you. Did you want to say more before I invite them to come in?
No, that's fine.
So the applicant then?
No comment.
I'm not quite sure what that means. It's either part of the Council's case or it's not. You can't say it's not part of the Council's case, but it forms part of a wider range of impacts. That, with respect, it doesn't make sense.
Is that what I was just... Perhaps if you clarify, I'm just looking at what I'd just been told. I understood I'd been told that it had been identified because there were some effects that were considered to be, well, that you say exactly what those effects were considered to be, but that it wasn't, that the threshold wasn't breached in the Council's view and therefore it had not objected on that basis. Do you want to just clarify?
Yes, so the threshold hasn't been crossed, so the Council don't raise residential visual amenity as a matter for objection. It was included in the reports simply to highlight high levels of effects. But I think that's causing Mr. Trinnick some confusion. I don't know whether that's clear to you, so...
Excuse me. Perhaps if you explain the distinction that you're making between a high level of effect or impact versus whether the threshold is crossed or not. I don't necessarily want to go into the detail of it, but just what the principle means. I think Mr. Campbell is maybe either giving you instruction. You can have a moment, yeah.
So not done these Hill SOS.
Well, that is a fair point. I think Mr. Campbell had perhaps misunderstood that. Yes, I think the
I think I don't know whether I can clarify it any more simply. So the Council don't object on a matter of residential visual amenity. The original assessments done by the Council did highlight, and also the applicant highlights very high levels of effect. It's merely to draw attention to those effects, but this is not forming part of the case and the matters for objection.
And I take it then, does that mean the Council is not disagreeing with the findings of the applicant?
Yes, that's correct.
Did you want to say anything on that?
No, nothing further to add.
Mr. Trinnick? Yes, of course.
Perhaps I paraphrase it another way. The council is not claiming any breach of the RVAA threshold. That's clear. But you draw attention to the high level of visual effects from properties falling short of RVAA. Is that correct?
Yeah, yes, I would say that was correct.
All right.
Okay, does that clarify matters for you? Yeah, okay, you're happy. No further response on any of the matters raised there, no? Okay, so does that conclude A? Yeah, okay. So, sorry, I'm not looking, I'm waiting for the... Okay, right, were you wanting to interject with something then? Right, let's move on to the next section then. So the key difference between DLH SOS stroke Mr and Mrs Whitfield versus the applicant appears to be the judgment about whether the residential visual amenity threshold has been breached, exceeded or not. So I suppose as I've then got a series of points which we're going to get into. We'll do B first. I suppose I'm implicit in that is whether that synopsis is accurate. So part B, what factors determine whether the residential visual amenity threshold has been crossed or breached or exceeded, and where can any relevant criteria or considerations be found? And I've said here this should focus on the theoretical matters, because further on in the agenda we're going to kind of get into the nuts and bolts of that on the ground. So, over to you, Ms. Platt.
So I would suggest the Landscape Institute technical guidance is the first port of call in terms of how the residential visual amenity assessment is undertaken and what steps are taken to determine whether a threshold is reached. It may be useful to open that document now. I think we'll probably have it open shortly.
Yes, okay,
anyway.
so...
it's 008.006.
Right, just give me a second to locate that. And did you say that's the Landscape Institute's... Is that the same thing as GRVIO 3 or is that a different thing?
No, it's the Landscape Institute Technical Guidance Note 2/19 and it's the core document number is 008.006.
Right, just a moment. Sorry, this will just take me a second. My system has chosen that moment to throw me out.
And I think perhaps page, I think it's electronic page 7 and paper page 7 is quite useful.
Did you say 008.006?
Yes, that's what I have, unless anyone else. Yeah, 008.006.
Okay, right. Sorry, just give me a second. That's my fault. I'm sorry, my system's not playing the game. Do you just want to proceed and you can tell me the relevant bits because I can go back to it?
So on page 7 there is a diagram with large blue boxes. On the left hand side it says...
I've got an unmarked copy.
Are you content? You know what this is? You're happy for me to see this? Yeah. Okay. Right.
So on the left-hand blue box, it says informed by GLVIA 3, principles and processes. So in essence, it forms an annex, an appendix, an extension, if you like, of the process to undertake a landscape and visual impact assessment. This is a technical guidance note specific to residential visual amenity assessment. This page goes through the steps which you would take to do the residential visual amenity assessment. So step 1, defining the area, identifying the properties, which in this case identified, I think, 13 properties. Step 2, evaluate the baseline and the visual amenity. Step 3, assess change to the visual amenity of the properties, identify properties requiring further assessment. And then step 4, which is the last step, which is where the decision about the threshold and any breach of the threshold is undertaken. In terms of the specific question which you had, which was relating to the threshold itself, that's the step at step 4. And we can go to the specific detail for that. Let me find. So that starts at paragraph 4.17. So any properties which, going through that process and those steps, are identified as having a high level of effect, they would usually be taken forward to step 4, which is to form the judgment of whether the threshold has been crossed. And the Landscape Institute guidance gives variety as to how you might make that decision, but broadly that rests on an opinion and a judgment on site as to whether that threshold has been crossed. So the examples that they give of descriptors are blocking the only available view from a property, and this is in paragraph 4.19, overwhelming views in all directions, unpleasantly encroaching or being inescapably dominant from the property. And those are suggestions for how you might consider whether the threshold has been crossed. There's also obviously the use of precedents, and certainly the council's approach, and I know that the council aren't objecting here, but often an approach is to look to precedent, and the Ennifer Downs appeal decision is one such precedent that's commonly used and referred to as the lavender test. Examples of descriptors which were used in that consideration would be, again, unpleasantly overwhelming and unavoidable, comparable to living actually within the turbine cluster, experience an unavoidable and unpleasantly overwhelming presence across the main outlook, likened to being inside rather than merely near a wind farm. So I think those hopefully give an idea of the sense of proximity, the sense of inescapable presence, and being a dominant factor within the views for residents. I think it's perhaps important to note as well that the steps preceding that judgment are indicative to how those final judgments may be made. And certainly it's been raised in this case that the element of step 3, which was undertaking further assessment or identifying properties requiring further assessment, would usually entail properties which may need to be visited in person, which wouldn't be undertaken in the earlier stages. And the purpose of that would be to ensure that there's an understanding of the curtilage of the property, the views from the property, and whether there would be any views likely to be gained inside, and if these would be considered the primary or main views from that property. and I raised that in relation to the assessment for old lands and lees specifically. Sorry, that's that concludes for that section.
Okay, would you like to respond?
Not really. I think it's been very well put by Calder Platt. The only point I draw attention to is paragraph 415 of the Landscape Institute document on internal page 12, which deals with the question of field work. I needn't read it out, but that is the advice given on visits to properties.
And that was paragraph 4.15, did you say? Just
it.
Okay, thank you.
Otherwise, nothing to add.
Okay. Mr. Campbell would like to come in. So, is this staying at the theoretical level? I appreciate we're getting into something. Yeah, okay, you go.
This is to do with paragraph 4.21 in the same document.
4.21. So this is on the following page. This is under the heading Field and Associated Activities, page 13. Is that correct?
Yeah.
Okay. So yeah, on you go.
Which states that in the event that access to private property cannot be obtained, having employed best endeavours to do so, assessment can then be undertaken from appropriate publicly accessible locations. So, best endeavours to visit the property, having decided that you got to step 4, I gave permission for a visit to the property, and it wasn't undertaken.
I appreciate I've got a specific question about that that's coming up. So
I
I realise you're marking it in the context of this. So
I'm just responding to the point that Mr. Trinick made about 4.15.
I understand, yes, the context, and I know how that sits with your wider concerns which you expressed, and we no doubt will come to that as we work our way through the agenda. Okay. Did you want to say any more, Mr. Campbell? Okay. I'll let the applicant come back then if you wanted to. No. Okay. So, unless there's any more, I think that concludes B. Yes. Okay. So let's move on to C then. So, if the residential visual amenity threshold has been breached, what would that mean in practice for the proposal and for the property for which a breach is found to have occurred? So again, we're at the theoretical level just here. Appreciate we'll get into the nuts and bolts of this as we go further. So I'll ask Ms. Platt again to take us through your thoughts on that.
Yes, I think in some senses this is more a matter of policy, but my understanding would be that it raises the matter to a higher level and it becomes a matter for residential amenity, which may then be combined with noise assessments, shadow flicker, and these other matters, but it would not. The end point of the landscape assessment will be to determine the threshold, and that's where it would be taken to as a landscape architect.
I'm sorry, could you just repeat that last bit again? I just missed.
Sorry, yes. So the end result of our assessment, if you like, in terms of the residential visual amenity assessment, will be the determination of the threshold, and that would be our end resulting output, if you like, as a landscape architect.
I see, and you're saying then the subsequent consideration of what that means is for policy. So
Yes.
it presents itself as an issue that policy may then deal with in the way that policy
Yes.
is written to deal with things such as that,
Yes.
and
That's
other things that may be related to it or be part of the broader consideration. Is that a fair understanding?
Yes. Yeah, that would be correct.
Okay.
In my understanding.
Okay.
I think Ms. Platt is right. It's a planning point rather than a landscape point, so I'll deal with it. I think if a house is not financially involved with the project, then if the RVA threshold is breached, Scottish ministers should refuse consent unless the nature and extent of the breach can be satisfactorily mitigated.
Just slow down a bit, let me catch up.
Yeah.
So in the event that the RVA was breached for an individual property that was not financially involved,
Yeah.
you said, I think, ministers should refuse consent unless mitigation can be shown to resolve
the
the issue.
nature and extent of the breach can be satisfactorily mitigated. As a matter of public policy, it's not really more to do with public policy than planning. Now, this case, I just note in passing, to put the thing to bed so it doesn't come and bite us later, for Old Langton Lees, the area of felling has been replanted, but we make no case that that replanting would be satisfactory mitigation. I'm just putting that out there. Of course, we also say there's no breach of the threshold, but where you determine there was a breach, we can't make a case about replanting. I'll just make that clear.
I'm very much obliged for that.
Sorry?
I'm very much obliged for that.
Sure. Coming on to the properties which are financially involved, that's Langton Lees Farm and Cottages. We can produce evidence if required as to how they're involved, but there's no dispute they are involved. They should not be regarded in the same way as properties which are not financially involved. And if you would like to go to document 1234 and 1235, but first of all 1234, is it playing ball?
It's just taking a moment to find.
The inquiry report first. Yeah.
Just while I'm waiting for that, what is 1234?
It's the nocturnal inquiry report.
Oh, actually, I think I've downloaded a copy of that. So just a minute. Yep. Okay.
Paragraph 150.
Which page do you know?
Electronic page 25.
25.
There, the reporters.
I'm sorry, paragraph 150. Did you say?
150. I'm using it as an example. It makes the point. Due to the specific siting location, layout, orientation, and use of the available outside space, Taylor Toll Cottage will become an unattractive place to live. So there you are. That's the phrase, unattractive place to live. I needn't go on to the detail of that because you get into site-specific detail, but at the end of that paragraph it's noted, however, the property is financially involved with nocturnal wind farm to compensate for residential visual amenity impacts. Note visual, not noise or shadow flicker, but specifically visual impacts. If you scroll down to paragraph 155, legal agreements would create financial involvement for certain properties, including Tell or Toll Cottage, to the extent the properties be considered as non-sensitive receptors for a residential visual amenity assessment. If the development was to proceed, an assurance would be required that financial involvement is secured. And if you scroll right down to page 292 on electronic page 48,
I'm sorry, page 48, paragraph 292.
292. And you were there before me. I'm doing it the old-fashioned way. I've got there. It's just noting, as reflected in our earlier conclusions, suspensive condition be used to require that suitable legal agreements are in place with the financially involved properties before development commences with regard to residential amenity, and a condition was added. Now, if we then go on to the decision letter, which is 1235, and you go to electronic page 16, and paragraph 100, there the ministers record what I've just rehearsed from the inquiry report, no more than that. Paragraph 100. If you then go on to paragraph 105, there's the finding about impacts on residential amenity, etc., etc. Oh, God, where are we? Electronic page 48. Hope to goodness I've got that right. Let's see.
This takes us to conditions.
If you look at condition 38, you will see the conditions that the ministers actually imposed, reflecting the reporter's recommendations. I'll let you read that rather than read it out. So that concludes my answer to your question in matter C.
And would I be right in assuming then that the position with regard to a financially tied property is because it's financially tied to a given proposal, there is some acceptance by the owner that having been financially tied to the proposal in question, they are accepting the consequent effects and therefore they are treated slightly differently to someone who would not be?
I think it's quite a complex question. But I only know what the reporter said. And the reporter classed up those properties as being non-sensitive because of the financial involvement. And I assume, therefore, because if you're getting something in return for the development, that has an effect on whether or not an effect on visual amenity is acceptable or not. That's the reporter's reasoning. That's all I've got. But it was endorsed by the Scottish ministers, which is important.
May I ask for a question of clarification?
What is that? Yeah.
Yeah, in relation to this point. You took us to paragraph 105, in which the reporters say, the ministers say, the impacts on residential amenity are acceptable when the impacts are weighed against the benefits that the development will bring. Could I ask you if you know whether that means that the ministers are taking into account the financial involvement of the occupant of that particular cottage, or is that a generalisation that despite the adverse amenity effects?
Very fair question.
Yes, I think that would be helpful if you had a view on that.
I can only help you on the basis of the document I've got in front of me. And what I've got is condition 48, which tells me that the ministers found it necessary to impose that condition in order that consent might be granted.
I'm sorry, just for clarity there, it was page 48 and condition 38 was, yeah. I think you said condition 48 a minute, so...
I have a follow-up, unfortunately.
Okay, let's see what that is then. Yes. What's your query?
Financial involvement first raised its head in the wind farm world in relation to questions of noise, and a parameter was set whereby if noise at a particular property was in excess of 5 decibels over the mean, then sorry, I put that well. An allowance was made for properties which were financially involved in relation to noise. My question is there a parameter anywhere which makes an allowance for disturbance to visual amenity, to residential amenity, in relation to visual matters rather than noise matters?
Do you mean as a matter of policy?
I do, yes.
No.
You're not aware of one?
No.
Okay. And in this context, we've got this decision in front of us that says what it says. So, and are you asking because you know of a particular? Oh, right. You're asking genuinely because you.
I'm breaking my own rule.
Oh, okay.
Asking a question I don't know the answer to.
Oh, right. Okay. Right. Okay. So, well, I think it was helpful to put that question out there. To, I think we're all clear that no one is aware of such a thing, and we've got the thing that we've just been referred to in front of us. So I can take that, and I've got it. Did you want to say any more? I'll let them come back and respond to any of that. I realise you've just responded, I suppose, by asking the questions to some extent. Did you want to say any more before?
No, thank you very much.
Nothing more. No. Mr. Trinick, any more? No. Okay. I think that brings us to the conclusion of part C. That's just come up on 4 o'clock, and we had said initially we would get to part C and see where we got to. I am happy to continue until possibly 5 o'clock if people wish to do that. I'll take soundings now. I realise Mr. Thompson might need to leave. So, but Mr. Wise is staying with us, I believe. So, yeah, okay. Mr. Campbell, you were happy to proceed with the agenda, were you?
Yes, thank you. I'm perfectly happy. As long as everybody's got stamina to do so.
Well, I'll hear what everyone's got to say.
He's got a second lease of life, so have I. We'll carry on.
Okay, that's fine. Yeah, I'm happy. Look, let's carry on, and we'll see where we get to. And I think if we get to the end of the day and we've not quite reached the end, then we may just need to pick up the remaining matters tomorrow. Okay, so section D carries on from what we were saying. Is an RVAA, a residential visual amenity assessment, expected to consider visual amenity from inside a property, from its garden or surrounding land, or something else? And where are the rules or approaches governing this approach set out? I suspect we've touched on this to some extent, but I'll very happily hear from Ms. Platt your views on that particular issue.
Yes, I'd like to take us back to the technical guidance note 219, which was 008.006. If anyone needs. So sections, paragraph 4.11, I think, deals with some of this. So 4.11 looks at evaluating the baseline, and it recommends that the following aspects are considered: the nature and extent of potential available existing views, garden, domestic curtilage, proximity to surrounding landform, land cover. This includes primary/main views from the property, domestic curtilage, as well as secondary and peripheral views. And it also goes on to discuss the experience when arriving or leaving the property from the private driveways and access tracks. I think that covers that one.
Okay, do you want to respond?
Yes, I agree with that.
No more to say.
Okay, so we've got agreement on, I suppose, the theoretical matters that position us where we want to be. Okay, so let's move. Now we get, I suppose, a bit closer to real life instances. So the applicant has carried out an RVAA, residential visual amenity assessment, for various properties, including the closest to the proposal, Old Langton Lees. And we've got various points, E, F and G. So I'll read those out. I suspect we'll try and have a go at each one. It might be sensible to do that. I realise that there'll be a possibility of drifting between the elements because there might be some overlap between them. So I'll read E. So the RVAA, the Residential Visual Amenity Assessment, includes wire lines from within the property grounds that exclude the Old Langton Lees shelter belt, all the remnants of it, and those I think are at EIAR figure 6.37A and B. There are also montages from the access track, and I just wondered if you could clarify which of these has been used to inform the residential visual amenity assessment for Old Langton Lees, and also for other properties, I suppose, and are these accurate and reliable? So I'll ask the applicant perhaps to start us off here, please.
Certainly. The RVAA for Old Langton Lees used the wire lines from the property, so figures 6.37 to 6. A and B, as the main source of information about the development. The additional montages produced in figures 650 to 652 were requested by the third party and included in the EIAR on the basis of that request. They're not included because the RVAA relies upon them. And that is set out in TA 6.6 technical appendix 6.6.
Excuse me. So is it fair to say that the residential visual amenity assessment is a bare earth assessment?
It is. It also includes some allowance for a little bit of screening with vegetation, as I'm sure we'll come to discuss. Yes. It is essentially a bare earth assessment, although it does allow for some limited screening, as I'm sure we will discuss.
Well, I was about to ask whether the residential visual amenity assessment, then, if it's bare earth, is that the premise from which the conclusions of the assessment are derived, and are assumptions then made for elements of screening? Could you just talk a little bit through those distinctions for me?
Certainly, it is made on the basis of the wire lines and information about the screening on the property itself as well.
So you said they're on the property, so and when you said vegetation, so might it consider garden vegetation within the property's curtilage? Is that the kind of thing that you would be meaning?
That is correct, yes.
So I realise we'll be coming on to it a bit later, but for example, the shelter belt or the remnants of the shelter belt adjacent to Old Langton Leys, those, as I understood, are outside the property, so that would not have formed part of the residential visual amenity assessment, based on what you've just told me, I understand.
That would not form part of the residential visual amenity assessment, and partly because it is a coniferous shelter belt that could at some point be felled. As it happens, it was partly felled, so it is generally excluded.
Okay, thank you. Did you want to say any more on E before I invite the... Oh.
Not at this point.
Ms Platt, Mr Campbell, Mr Whitfield, I'm not sure who will be speaking to this. It may be a mix, so perhaps if you want to respond, and then we'll...
Go first. Okay.
You can go first. Right, okay.
The RVAA in the technical appendix mentions the filtering from the shelter belt 3 times before it then says, even if that wasn't there. So I don't understand why the sheltering of the filtering from the shelter belt is mentioned so many times if it hasn't been involved in the assessment.
So when I'm reading through that, do I understand properly your contention is, you obviously were listening to the discussion I was having just there, that this is a bare earth assessment that the applicant was saying does not include the shelter belt, and your contention is when you read the technical appendix which contains the assessment, you read it that it does contain that.
I read it as it says 3 times, it is filtered by the shelter belt, and then the last sentence it says something along the lines of, but even if it wasn't there. I don't understand why it's mentioned 3 times in the preamble and then discounted in the conclusion.
Okay. Well, in a moment when we've heard from any other points that need to be made, I'll let the applicant respond. So, Mr Campbell, Ms Platt, do you need to say anything more?
I think I would concur with Mr Whitfield in the sense that it's perhaps introduces a bit of confusion. My assumption is that the filtering is mentioned as part of the description of the baseline, but it does seem to suggest that there are mitigating factors introduced through the filtering of the trees and the shelter belt, even if this isn't where the assessment judgments are based on.
Yeah, can you just talk me through that, please?
Certainly. The shelter belt was present in a damaged form at the time of my assessment. I did observe that there was damage and that there was going to be a little bit of filtering if that was maintained as such. I also assumed that it would be cleared at some point and made allowance for that. So I've not included the screening by the shelter belt as part of the assessment.
Did you want to say any more?
No, I don't think so.
I'm sorry, go on.
What I've got to say might answer what the question. We'll see. So the baseline situation recognises the existence of the remnants of the shelter belt. You said there that at the point when you did the exercise, it had been damaged, and therefore you made no assumption for screening effects of it. Going back to what you said before, the RVAA was a bare earth assessment. So we have a baseline with the remnants of a shelter belt. You then do a residential visual amenity assessment that assumes it's not there anyway. And
that was considered in the assessment, yes.
any more before I invite the other party back?
No, I think so.
Mr. Campbell, yourself perhaps, or Mr. Whitfield or Ms. Platt want to say any more?
As I understand it, Ms. Dower only viewed the house from the track. She couldn't see the vegetation in the garden from the track.
Sorry, I'm just hesitating because I'm checking where we are on the agenda to make sure that I realise there's a specific question that gets into this, so I just want to make sure I remind myself where it is. Yes, we're drifting towards F. I'll hold that for a minute. We will pick it up. Regards the other matters that were discussed. So on point E, I've been told, I think, what was included and what wasn't. Did you want to add any more before we move on to F?
No, thank you.
Nothing further on that. And were there any other points you needed to address before we move on to F? No. Okay, so let's move on to F then, which I think introduces the point that Mr. Whitfield was just making. So where and what areas did the site visit by the applicant's consultant include in the vicinity of Old Langton Leas? Was the garden of Old Langton Leas visited, or is the RVAA reliance based on the wire lines in EIAR figure 6.37A and B? Now, I am aware that a point has been raised about EIA competence. I have got sufficient information from both sides on that, so we don't need to get into that at this point. This is simply a question about the facts that have been put here. So I'll ask the applicant to go first on this. I suppose Mr. Whitfield has pointed that out to us already. I suspect I have an indication of go with this, but we'll hear from the applicant first and then you'll be able to respond.
Thank you. My site visit, including walking along the public right-of-way from Langton Leas to Camp Moor, which passes the property gate and includes views of to the property as well as to the site. Looking in from that track, you can see some vegetation from the garden. You can see the hedges around it. You can see a couple of mature trees. You can see trees along the track. From my desk research, which included not only the wire lines, but also perusal of aerial imagery, and my walk along the track, I believe I gathered sufficient information regarding the layout of the property to make my assessment.
So when you were looking towards the property from the track, and you'd indicated to me obviously that the shelter belt had been largely damaged, did that enable you then to see from the track the property in order that you were able to gather the information that you were just talking about?
It was not possible to see the property from the section of track that runs directly past the shelter belt, because there were still fallen trees and so on at that stage. It is more open now. However, from further south and further north, it is possible to see to the property.
But it would be fair to say, and Mr. Whitfield's point was that you didn't visit the actual property itself. You didn't set foot on the grounds within the garden or perhaps the driveway. Is that fair?
That is correct. I was at the gate on the driveway, but not within the property.
And when we were talking a few moments ago about the document, forgive me, I'll just remember the title, the Residential Visual Amenity Assessment Technical Guidance Note 2/19. Just thinking about some of the components in there, your choice to not visit the actual property follows, does it, the relevant components of this approach?
I'm acting following the guidance, yes.
Okay. Do you want to say any more?
Sorry, no, I do want to say a bit more.
Okay.
Coming back to the question of a site visit. A site visit was arranged for the 22nd of November 2022. Yep,
Okay, just a minute.
if I could
Just a minute.
continue, please.
Sorry, just a minute. Right.
Thank you.
I'll let you come back in a moment. So, Mr. Trinick, your dates that you gave me was
November 22, anyway. Doesn't really matter which day of the week.
November 2022. Okay.
I've read the correspondence myself, quite extensive correspondence between the applicant and Mr. Whitfield on this point. That site visit was arranged, but it was then cancelled by Mr. Whitfield. No further offer of a site visit was made until after the submission of the application. Those are the facts. Thank you.
So, in a moment, I'm just writing. I'll let you come back in just a second. Okay, and I appreciate this is an emotive topic, so that is clear to me. So I understand that. Okay, I'm happy for you to respond.
This was November 22, so I was asked for a visit. At that stage, I had a professional advisor, and I was confused for many months about the difference between an RVAA and a photo montage. I spoke to my advisor. He thought they were coming to do the photo montage. He said, look, the weather's not very good. You want to come on a better day? I said, fine. There were emails back and forward between myself and Fred Olsen. And on the morning of the visit, I got clarity and I gave permission for that visit. On that morning, I have an email to that effect, which I'm happy to provide. I then chased that on more than one occasion afterwards with Fred Olsen. To be fair, I did not have direct communication with Dower, but I did have communication with Fred Olsen, and I chased that on more than one occasion. I can dig out whether it was one or two occasions, but I think it was two, to ask when that would be coming, and twice I was told I'm pretty sure it was twice I was told, once as soon as possible, and the second time they would be in contact when I'm going to try and find the right words, the layout was finalised, and I was never contacted again, having been told twice that they would be in contact at some future date.
And I've had submitted to me, haven't I, various different email chains. I'm pretty certain in amongst some of the submission material that you've
I think
sent.
they are, but I'd have to dig them out again. But I can produce those quite easily.
I'm pretty sure I've read some backwards. I was aware of the context. You've rehearsed to me a context of there is a position of disagreement between the pair of you about exactly what happened. I think both parties have provided me with various different. Do parties at least agree that the origin point from which those wire lines look is the western elevation of the property? Would that be fair? The elevation of the property that faces the direction of the development. Yeah. Okay. Is that your?
I think the origin point of the grid reference, of the wire lines, the grid reference is taken from the OS postcode data, which I think is near the western facade of the building, but within it.
In the building or within the curtilage of the building?
I believe the point actually falls within the building.
So the forgive me my terminology, the spot on the map would be situated within the centre point of the building, and the wire line is looking towards the development, which is towards the west from, or nearly as near as it can be, to the western elevation. Is that correct understanding?
Yes, the dot would occur within the rectangle that defines the actual building, but at the western end of it.
Okay, and is that relatively close to your understanding, Mr. Campbell, Mr. Whitfield, of?
Yes.
Yes. Okay, that's fine. Okay, does anybody want to say any more on F before? Did you want to say any more on F? No. Any further things on F?
No, thank you.
Okay, so that moves us further on. So we move to Part G now. So parties represented by Mr. Campbell, including Leader Hattrick and Mr. and Mrs. Whitfield, have prepared their own wire lines and montages. And I stress I don't think it's they themselves. I suspect it's the consultant, but you'll be able to clarify for me, which appears to have been done by Monroe Landscape, which I understand is DLH SOS's consultant, and you can kind of correct any misassumptions I've made there. So I've asked, what are these based upon, and are they accurate and reliable to demonstrate the positioning of the turbines and other elements of the proposal? There's been some discussion, hasn't there? I think the applicant had some queries, Mr. Campbell, which you endeavoured to provide a response for, which I think you've done to the applicant recently. And as I understand it, this was part of the nature of the discussion that was happening this morning during the break. So would you be able to update me on where things are by your understanding, and hopefully in a manner that will assist us in answering this question?
Yes, very helpfully, Ms. Dar has raised issues about the precision of some of these and how they were made. My decision in the end of the day is to withdraw 4 documents, or to seek to withdraw 4 documents. And they are numbered 014050, 014044, 014032, and 003.033.
And just so I'm clear on which ones those are, and just for everyone's benefit, could you just give either the title or a synopsis of the title? So
I haven't got that written.
Oh, right, okay.
I thought I might put this in a document overnight.
I was about to ask if you could just give me an email that could be copied into the other parties so that everyone's got an understanding of which ones those are. That would be very helpful.
I haven't been able to provide this information before because I haven't been able to get in touch with the photographer. Monroe Landscape was not the photographer. Mr. Johnson was the photographer, and he was working for us. So I've made contact with him, got this information, and I want to withdraw those documents now. And I'm grateful to Mr. Starr for raising the issues of accuracy, which broadly I accept.
Thank you for dealing with it, and so much appreciated. Just clarification, 014044 is a long report with some images at the back of it. But are you withdrawing the whole of it, 044, or simply the images? Images, right, that's fine.
So as I recall, that's helpful.
And any reference to the images in the text.
Yeah, fair enough. Okay.
Yes, I recall I think there were some positioning of proposed turbines in those images. Do I recall that correctly? I think. So, and for absolute clarity, perhaps if you can make that point in the email that it's the images and the references to the images, but you intend to retain the remaining text part of the document, as I understand from what Mr. Trinick's question was. Okay.
I mean, obviously, one would rather not do that, but it involves it would involve a lengthy and technical discussion about how these wireframes were made, how these front montages were made, and the allowance for adjustment. You appreciate this is a computer-driven process using software, which I don't fully understand, I confess, and therefore I would have to have it explained to me, and we would be here for, it'd probably take a couple of hours to explain properly. Would that be fair? Yeah. So I'm not going to burden you with that.
So is it fair for me to understand that documents you've listed to me and that you'll, that you'll provide further detail on those documents that are withdrawn are ones that involve the positioning of turbines in montage views and associated wire lines? And are those ones that were from Old Langton Lees and Leader Hattrick's property, or just one of those? I'm sorry, I'm asking you this because I can't recall at the moment which numbers these are. That's fair enough. On you go.
Or perhaps not. Okay, so it relates to montages which are in connection to initial planning objections. So there was a montage, a visualisation from the garden, which forms part of the withdrawn documents. Also related to that same document, I think, is an internal visualisation from inside the property. There is also the withdrawal of one of the figures which relates to my RVAA report, which is also an internal visualisation from inside the property. I think I've got that correct, but Ms Dower might offer further clarification.
Fourth one.
Is there a
Fourth one.
Yeah, I'll just have to check because I can't remember exactly which ones they are.
Okay, I'll let the applicant say what you want to say.
Can we clarify by email? We're happy with that.
Yeah. Okay. So I think yeah, the email clarification is probably going to be really useful to all of us, because then I can absolutely understand. It gives you a chance to set out and make sure, obviously, that the
Obviously needs to be completely accurate for you. So I'd rather do that in writing.
yeah, I'm happy to receive that. So, is that something that will come to us before tomorrow, do you think, or is it? Yeah, Mr. Trink. Sorry.
I can't see any reason why not. As long as we get out of here sooner or later.
Mr. Trink.
I'm asked to clarify 14031. Is that one of the withdrawn ones or not?
Is it? I think I got 003.031. Would that be correct? Sorry, do you want to repeat that?
Does it matter? There's no turbine.
Yeah, I think I'm just hearing Mr. Trinick's whisper there about whether this matters. I think the clarification by email is probably going to be the most helpful thing for all of us. And then I think if there's bits and pieces around this, we can pick them up in closing, and because I think it's going to be quite difficult for us to talk about those. But I'm grateful for the clarification, and obviously for those who participated in the discussion that has facilitated this. Do we need to say any more on point G? Any more points you want to raise, Mr. Campbell? I suspect the nature of my query was simply to draw out whether parties were content that the additional visualisations and wirelines that were provided by DLH SOS and Mr and Mrs Whitfield and Leader Hattrick were regarded as reliable and accurate by parties. I was simply trying to understand by the question whether I could use them interchangeably with the information provided by the applicant. So, yeah, I think I was, while you were in discussion, my apologies for talking over you. So the purpose of question G had been to understand whether the imagery provided by DLH SOS, Mr and Mrs Whitfield and Leader Hattrick for those properties, whether that was interchangeable for me when I looked at the material that the applicant was producing. And what I think I can take from what you've told us is that the documents that you're withdrawing are ones where there is can I use the word doubt about whether that would be possible, and therefore you're withdrawing them, and the other ones that you aren't withdrawing, there is consensus that I can use them interchangeably with the applicant's material to at least draw comparisons. Is that your understanding? I'll let the applicant come back.
That's my understanding.
Mr. Trinick?
Yes.
Thank you for the brevity there. Yeah, okay, good. I think I'm clear, and we'll have absolute clarity when Mr. Campbell provides us with those details. So thank you, appreciate that. And as I mentioned, people can pick bits and pieces up in closing. Right, okay. So how are we doing? We're making good time. We've got half an hour, so that takes us on to H and I. Somebody mentioned J, but I think that's just I. Okay, so the reporter visited Old Langton Leys in September 2025. He saw the shelter belt that has now been largely removed following storm damage. He saw some remaining shelter belt trees along the edge close to the access track at the north end, all along the Old Langton Leys Drive, and along much of the southern and central part of the western boundary of Old Langton Leys. Further, the reporter also saw adjacent the western elevation a vegetated slope with tall shrubs, trees. It was also topped with a flat area with a wooden garage apex roof, perhaps between 7 and 8 feet tall, and behind it to the north a wooden shed of similar height with a single panel sloping roof. So my question H is, what screening effects, if any, would the remaining shelter belt trees have? I think we've touched on this a little bit, but I welcome views, including garage and shed, south, the front, and north rear elevations of Old Langton Leys in terms of residential amenity. And should these features have any bearing on the findings of the RVAA? So I'll perhaps invite Spratt, Mr. Campbell and Mr. Whitfield to come in first on this, and happy for you to correct my observations here if needs be, whether that's accurate, and if you can then address the issues, please.
It might be useful to pull up some of the visuals which are remaining and have been considered sufficiently accurate. These would be 14.025. This is taken from the north side of the property, and
Just a moment, let me find it.
Yeah.
I think I've got these with titles in old money. Do you happen to know the DLH?
I've called it Figure 1A. It says DLHL5, Figure 1A, WP7 base.
That's fine. I've got paper copies here, so if anybody in the public gallery wants to look at those, so if people want to look on the laptops, you should be able to find them. So what I think I'm looking at here is we've got a photograph which looks like an existing photograph. It has, it's relatively near the centre of it. Is that a part? Is that some garden furniture?
Yes.
Yeah. Okay. So we're on the right one. Okay.
So this depicts the view from the north side of the property, looking towards the development, looking to the west, and you can see to the, I'd say the left-hand side of that panorama, there are sort of heaps of brown matter. That's the residual bits of the shelter belt. So I'd say that the shelter belt there is fairly clear. There were little bits of it remaining during this photograph, but not much screening offered. The large mature tree, which is central to the picture, that's a mature tree standing within the grounds of the property. It's a broadleaf tree, and the expectation would be that that will remain until its life ends. And it can be considered to provide some filtering in the summer months, but as a single standalone tree, it doesn't offer an extensive amount of filtering. There are some other small bushes which do provide filtering, but you can also see below that image the positioning of the turbines and where they will appear and how they may appear within the clear gaps. Obviously that changes when you move around the garden, but it does depict the level of visibility which is available and will be the residual experience from the north side of the property. The next image, which
I'm sorry, can I just
Sorry.
pause on that one? So obviously I'm looking at, so the wire line underneath is positioning the turbines in the location they will be seen on the kind of skyline of the photo above, from what I understand. So I can see in the distance, can I, an existing shelter belt, is that the one that sits on the top of Lees Hill? I'm just
Yes.
looking, I suppose, above the garden furniture, if you like, in the gap for the tree. So that might partially obscure a little bit of turbine 4, is that?
Yes, I was going to draw you onto the
Okay.
montage, which illustrates graphically the potential screening that you might see. So if you moved on to figure 1B, if that's a good reference for you, which is 014.026. And it's listed as DLH L6, figure 1B, WP7.
Yeah, I've got that.
So there, as you said, the sort of dark. I mean, this, and to note that this is a 90. Sorry, this is the 53.7 degree view, so it's a reduced horizontal span. So the woodland on the horizon, as you said, is likely to screen or will screen the majority of the turbine placed behind it. The screening effects of the tree are illustrated, so there will be some filtering, as I say, in summer months within that tree. And then the residual mounds of the shelter belt to the left are offering screening, but they will be removed. And there is some screening to the far right with the tree there. But the determinations within my assessment were that these filtering effects are quite minimal, and also to be mindful that these are moving elements within the landscape and may appear more notable than they appear on the photograph.
Which one are we going to do next? 2A?
The front, I think. There's just a note there that that's also representative of the view from the kitchen window. So the windows to the north side of the house, which is the kitchen and the dining room. I was going to take you round to the other side of the house, if that's acceptable. So that's figure 2A, is that correct? Which is 014.27. So this illustrates the views from the south side of the house, and you can see again that the image to the top, the panorama there, is the base panorama. There are some residual trees and bushes, and there will be some screening through those elements. It doesn't show the shed, and I might leave Mr. Whitfield to discuss the shed with you. It doesn't appear on my visuals, although I do know that it's sited to the side of the house. But this hopefully illustrates the vegetative screening. The montage which is associated with this is found on 2B, which is the following figure, and the screening effects are illustrated to that's figure 14.28, DLH L8, figure 2B. And you can see there that the filtering is demonstrated from the vegetation, but that the turbine to the left stands quite prominently. I'd also note that this particular turbine, which is turbine 1, does appear as one of the most prominent ones and is particularly visible from this location, and it's this turbine which is potentially visible from oblique views from the upper windows of the house and the front rooms.
Did you say they're from the upper floor and front rooms?
Yes, that's my understanding. We haven't produced visualisations, but in terms of siting and location, my understanding is that it will be visible for oblique views, not the direct view out to the front. I don't know if Mr Whitfield wants to speak about the shed and potential screening.
So on the picture that's there, the garage is directly in line with the house. You can't see it, but effectively it's directly west of the house.
Yeah, I recall seeing them, and I think both structures, I think, as you say, I don't think they passed the front or the back of the house. Would that be fair?
They don't.
No.
And in terms of your filtering point, although Kel hasn't quite made the point, from the upper floors, you can see straight over the top of those buildings.
And is that through the side windows or through the?
Well, yes, it's the windows on the west side, but as Kel has pointed out in her report, all the rooms have double aspect. So the rear bedroom, you'll see effectively the view that we saw in the first picture. So you see straight over what was the shelter belt from the upper floors.
Thank you for clarifying that. Okay. Is that us? Do we have any more points?
I think that's all I wanted to speak of on that matter.
Mr. Trunick.
Consulting with BDA, what's been recorded is purely factual. It's perfectly fair, it's perfectly accurate. It's for you to assess on site. We can't add any more in this room. You have BDA's evidence on the topic.
So there's no dispute with any of the points that have been made, and I think you'd clarified earlier I can use these montages interchangeably with the applicants because there's no dispute on the accuracy of these.
That's correct.
Right.
And you didn't want to say anything more in response? Okay.
No, because this is a matter which is hard to judge inside the inquiry room. It's a site visit issue. The facts have been correctly recorded. Over to you.
Yeah, I mean, I've been on site. I've obviously had the opportunity to look. So what I'm seeing is stuff that I'm aware of. It's very helpful to have the factual context for people to explain. I think you said before there was nothing further you wanted to add.
No, I think that the photo montages are quite useful in taking you around the property. So I think I don't know whether you intend to visit the property again, or it may just inform your judgment. I think I just wanted to add that it was, from my assessment, it was the high effects on the access road which really compounded the potential to reach the threshold because of the experience of arriving to the property at each arrival into the wind farm, and then obtaining the views from within the property to the turbines once the property was reached.
Okay, thank you for that. That wasn't something that was raised previously, so you can respond if you like.
Yes, I'd like to point out that the track in question is a public right-of-way, is therefore not a private access road. It's been addressed in the RVAA in terms of context of approach and departure from the property, but it's not part of the property.
But it is the only access to the property.
Not disputed. Not disputed.
And again, I can confirm that on my site inspection, I travelled the route in both directions, both to and past the property, because this is also, although not necessarily in the context of this, that is also a route that was assessed as part of the LVIA for, as you say, public rights of way. Is that correct?
That is correct, and the right of way continues south of the property as well.
Yeah, so I was obviously able to look at it in both contexts. Okay, did you want to say any more before we close this section?
No, I'm happy with that.
Did you want to say anything by way of close on this section? No, nothing further. Okay, very well. That brings us to the end of today's agenda on landscape and visual, including cumulative and residential visual amenity. That's been extremely helpful to me to have these discussions and to hear firsthand the different positions on the evidence, and particularly I think for all parties to take me through the visual evidence. I found that very, very useful, and that will assist me. I'm very grateful to everyone for the extra time. We've gone quite a way beyond what we normally would sit. That's just coming up on 10 to 5, and I'm grateful to everyone for their brevity and focus in assisting us to get to this stage. Tomorrow we will commence at 10 a.m. And we will be dealing with policy followed by draft conditions. So you're in for a treat. It's a double header tomorrow, so 2 different sessions. So there you go. So we'll start that at 10. So if people can be arriving ready for that to commence at that time. Mr. Campbell, can you pull on?
Sorry, can you just confirm that in the policy session you only want to hear about socio-economic issues? You don't want to hear about energy and planning policy?
That is correct, yes. So the matter on the agenda is the sole focus of that.
Sole matter, right.
Okay, safe onward journey everybody, and I look forward to seeing you all tomorrow.